Good morning. Today is April 17th of 2024, and the current time is 9:02 a.m. This proceeding is being held in room 310 of the Governor Office Building. The Commission has set aside this time today for day 3 of the Ameren securitization hearing, and that is in the matter of the petition of Union Electric Company doing business as Ameren, Missouri, for a financing order authorizing the issuance of securitized utility tariff bonds for energy transition costs and related to Rush Island Energy Center, and that is file number EF-2024-0021. My name's John Clark. I'm the regulatory law judge presiding over this hearing today. There are no commissioners down here yet, but there will be commissioners that are coming in and out through the day, and there will be commissioners that will join us via WebEx. Both to observe the proceedings and to ask questions. We have a new court reporter again today. We seem to be switching court reporters each day. So the first time you get up or so, if you're a witness, be sure that the court reporter catches your name. At this time, I'm going to ask counsel to enter their appearance on behalf of their parties, starting with Ameren, Missouri.
Wendy Tatro.
Jim Lowry, also on behalf of Ameren, Missouri.
Ms. Tatro, Mr. Lowry, thank you. On behalf of the staff of the Commission.
Nicole Mers on behalf of the Commission, and Travis Pringle will be appearing on some issues later today as well.
Thank you, Ms. Mers.
Travis Pringle.
On behalf of the Office of the Public Counsel.
Nathan Williams, appearing on behalf of the Office of the Public Counsel and the public.
Thank you, Mr. Williams. On behalf of Midwest Energy Consumers Group.
Good morning, Your Honor. Tim Opitz on behalf of MECG.
Thank you, Mr. Opitz. I do not see an attorney for Missouri Industrial Energy Consumers. They had requested to be excused except for a single issue, and so they are not expected to be here at this point. Renew Missouri, likewise, asked to be excused except for their singular issue, and so they have been. Natural Resources Defense Council requested to be excused from the entire hearing. That was granted. AARP and Consumer Council of Missouri.
Thank you, Your Honor. I'm John B. Kaufman, appearing on behalf of AARP and also on behalf of the Consumers Council of Missouri.
Thank you, Mr. Kaufman. And the Sierra Club had similarly asked to be excused from the entire hearing, and that was granted. Are there any preliminary matters that the Commission needs to take up at this time? I hear and see none. When we left off yesterday, we left off with issue 5, planning for NSR outcome, and we were about ready to start our second witness, and that would be staff's witness. Staff, you may go ahead and call your witness.
Staff calls Sean Lange to the stand.
Did you say Laney or
Lange, but I will ask him to spell it for you.
Mr. Lange, would you raise your right hand and be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Staff, you may proceed.
Can you please state and spell your name for the record?
My name is Sean, S-H-A-W-N-E, Lange, L-A-N-G-E.
And did you file testimony in this case that has been marked, it's the rebuttal, your rebuttal testimony marked as Exhibit 108 and surrebuttal testimony marked as Exhibit 109?
Yes,
And do you have any corrections to that testimony?
not to my knowledge.
And is that testimony true and accurate to the best of your knowledge and belief?
Yes,
And if I asked you those same questions today, would your answers be the same?
yes,
This is Mr. Lange's last time on the stand, so I will go ahead and offer his Exhibit 108 rebuttal testimony and Exhibit 109 surrebuttal testimony for the record.
Are there any objections to admitting the rebuttal testimony of Sean Lange, Exhibit 108, and the surrebuttal testimony of Sean Lange, Exhibit 109, onto the hearing record?
Well, there's not an objection to provisionally admitting it, but there's a motion to strike with respect to, oh, that's his rebuttal. I guess it's a rebuttal, I'm sorry. No objection, only rebuttal. My apologies, Your Honor.
Okay, Exhibit 108 is admitted onto the hearing record. Exhibit 109 is provisionally admitted onto the hearing record, subject to the arguments in the motion to strike and the commission ruling on those arguments. Thank you for reminding me, Mr. Lowry.
Sorry, I got those mixed up.
And staff will tender this witness for cross.
Are there any questions from AARP or Consumer Council of Missouri?
No, Your Honor.
Are there any cross-examination questions from MECG?
No, thank you, Your Honor.
Are there any cross-examination questions from the Office of the Public Counsel?
Not at this time, thank you.
Are there any cross-examination questions from Ameren, Missouri?
No questions, Judge.
Are there any commission questions? And this is twice for you. I have no questions for you, Mr. Lange. I found your testimony quite clear. So since nobody has any questions, you may step down.
Thank you.
Staff, you may call your next witness.
Staff calls Brad Fortson to the stand.
Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated.
Can you state and spell your name for the record?
Brad, B-R-A-D, J. Fortson, F-O-R-T-S-O-N.
And did you prepare or cause to be prepared rebuttal testimony that has been marked as Exhibit 104 and corrected rebuttal testimony that has been marked as Exhibit 105?
I did.
And do you have any further corrections to that testimony?
I do not.
And is the information contained within true and accurate to the best of your knowledge and belief?
It is.
And if I asked you those same questions today, would your answers be the same?
Yes.
This is Mr. Fortson's last time on the stand, so I will also offer Exhibit 104 and 105 into the record.
Are there any objections to admitting Exhibit 104, the rebuttal testimony of Brad Fortson, or Exhibit 105, the corrected rebuttal testimony of Brad Fortson, onto the hearing record?
No objection.
I hear and see no objections. Exhibit 104 and Exhibit 105 are admitted onto the hearing record.
I tender the witness for cross.
Is there any cross-examination from AARP or the Consumer Council of Missouri?
No, thank you, Your Honor.
Any questions from MECG?
No, thank you, Your Honor.
Any cross-examination from the Office of the Public Counsel?
Not at this time, thank you.
Any cross-examination from Ameren, Missouri?
No questions, Judge.
Any commission questions? Okay, I just have maybe one or two questions for you. We'll see where we go. What, and you were here yesterday when I maybe unfairly questioned Ms. Eubanks.
I was.
And do you want to give me your take on why this is a separate and distinct issue from the plant retirement?
Yeah, so I think Ms. Eubanks did a good job of trying to explain sort of the situation. I think a couple issues got sort of lumped together. Ultimately, my testimony was filed for historic background of IRP planning, and Ms. Eubanks referenced my testimony as support for her proposal for the hold harmless. So ultimately, I think the issues may likely have been able to have been put together in a different and better, more clear, concise way. But ultimately, my testimony being what it was, I think the bigger picture to me on this issue is more so the hold harmless piece of it, and could that have been, included somewhere else more clearly? It probably could have been.
And I'm going to say again, and I think I was maybe a little unfair yesterday. Myself, and I believe the commissioners too, deeply appreciate the fact that you guys go through the hard process of delineating the issues so that the commission knows exactly the decisions that it needs to make. And so I know that's a hard process because it involves a meeting of the minds of all the parties. And that's hard in a case where, you're not reaching a settlement and we're here at the hearing. So again, I went to express that I really do genuinely appreciate everything, and it is impossible to get everything perfect. And most of my questions, again, center around my inability to understand the issue. But I do think there's some very valuable stuff in there, and especially in regard to the IRP, because this is, obviously this is not, we are not assessing the prudence of their IRP planning. But you're trying to give a historical background towards the prudence of their decision, or I guess you might say failure to make a decision to plan for a possible negative court outcome. So what I would like for you to do, if you could give me a little background, since you do have the knowledge about the IRP planning process and that, can you kind of meld the IRP, what Ameren was doing with their IRPs as it relates to those 3 court decisions?
Sure. And that's really exactly where I was going with my testimony, was to point out, in my opinion, and I think factually, with the 2011, 14, and 17 triennial IRPs, the company didn't explicitly plan or state that they were planning for a negative outcome of the NSR litigation. The company will contend that they did have models that showed an early retirement of Rush Island in the year 2024, which happens to be the outcome of what ultimately happened. But my point was that it wasn't explicitly stated that that's what they were planning for. It was the models that were planned for a Rush Island early retirement. They did have certain models that showed the scrubbers being installed, but for a carbon tax in the 2024, 2025 planning years. So my testimony, was really intended just to show that I believe that the planning could have potentially, one, could have ultimately been planned for, for a negative NSR litigation outcome. That wasn't in fact what was done. I believe those models would have, or the outcomes of those models could have been different by some amount. I think certain assumptions would have changed if you're specifically looking at the negative outcome as opposed to early retirement due to a carbon tax. I can't sit here and list or even state what the company may or may not have done differently. It just seemed to me, for purposes of this case, pointing out that I thought what was potentially a lack of planning for that outcome. The company has mentioned Mr. Lowry in my deposition and Mr. Michaels in his surrebuttal testimony. Staff didn't raise any concerns or allege any deficiencies throughout that time frame, specifically in regards to the company not modeling it in that for that certain outcome. I can't speak to, for several of those years, why that may have been. And it may have ultimately been that staff didn't have a concern, given that they didn't know how the outcome was going to be. But again, the testimony was more for, just a historical background from, I guess, my point of view.
I believe I remember reading in your testimony that you had asked Ameren why they hadn't planned for a negative court outcome, and that the response you received back was that it was not their policy in their IRP planning to include pending litigation. Is that correct?
Yes, that was my understanding. And I know that the Sierra Club had sent the company a data request asking that specifically and got that response. I recall that response through discussions with the company, but they did respond to a data request to Sierra Club stating that.
Did they tell you why?
No more so than just, it was, or my understanding was it was the policy of the company that, that was pending litigation. That was a pending issue that I understood that they didn't feel was appropriate to plan for while it was pending.
I believe I remember reading in Mr. Mitchell's testimony that that they believe they were just following the rules for IRPs to minimize the revenue requirement. Does that make sense in regard to planning for negative legal outcomes? That's not a very well-worded question.
I think I understand where you're going, and I don't disagree with Mr. Michael's characterization of NPVRR, and that being the primary driver of comparing those plans. And again, I mean, they would have likely, ultimately compared the NPVRRs of any plan, of any modeling that they did, including, had they done a plan specifically for the negative outcome of Rush Island litigation. But ultimately, what he said makes sense. I don't know that he mentioned it or was speaking necessarily to planning for the negative NSR litigation outcomes, but his characterization was fair.
Now, no amount of IRP planning would have made a difference at the end of the day in regard to whether they have to close the plant or not.
That's true, and I think you got to that late yesterday when I think you said we are where we are, and yeah, the IRP planning. I offered up thoughts of, had they planned differently, maybe there could have been a smoother transaction once that outcome was final. Again, that was more suggestions or thoughts as opposed to, this is how it would have, there would have been a smoother transaction or transition. But yeah, ultimately, we are where we are because of, the court order and what Ameren is now required to do with Rush Island.
I went home and I gave this issue a lot of thought because, as I indicated, I've had some difficulty wrapping my head around it. And one of the conclusions I had asked Ms. Eubanks, which essential bucket the harm went into. And I think my supposition at the time was, well, it can't be both. But then I went home and I said, well, why can't it be both? That doesn't, you know. And I also considered, you know, if the commission is determining that the plant retirement may be prudent, but the NSR is not, it might be another way for staff to get to that harm. However, and especially it seems to me when coming at it through the failure to plan for a negative outcome, even if the commission were to agree with staff, it seems that even more so than the plant retirement issue, that what harm would come over this multi-year process would be highly speculative and absolutely non-quantifiable. Do you believe that's a fair assessment?
I do think currently that's a fair assessment. I think there was certain potential harms, or at least maybe a harm, that Ms. Eubanks spoke to that may have a more clear quantification. But I think you're exactly right. There could be a number of potential harms that could come about because of the negative outcome and going forward. I think one of our staff's biggest concerns was, you know, if the commission were to find that, you know, what Ameren is doing, you know, with the retirement of Rush Island, it being, you know, if they determine it's prudent, our concern was that an order could read that could imply that, you know, limits or even precludes staff from bringing or raising further issues or prudency issues in future proceedings. And I think that's sort of where some of the testimony has sort of, you know, is trying to guide the commission that, you know, if you determine it to be prudent and you know, staff has no, staff's position is, you know, that it is prudent for Ameren to comply with the court order and to retire Rush Island accordingly. We just want to preserve our right to bring up further issues, potentially for harm in the future.
And I actually thought about that last night as well. So many of the things that staff has pointed out that it's attempting to preserve, it seems like that staff is doing that simply because there's no way to calculate now. And then down the road, maybe closer to a next rate case or even beyond that, that is when those items will become known and knowable. Is staff using its hold harmless provision in this case, beyond what's been said about customers, and I don't want to go into any in-camera information. Well, if you're going to go into in-camera information, let me know so I can go in camera. But and I heard Ms. Eubanks say yesterday, these are amounts that we have a pretty reasonable idea that the estimates are fairly solid. Is staff wanting to preserve the non-quantifiable harm for the future, yet have the commission make some sort of decision here, and as to that perhaps staff could use later?
Yeah, I mean, I think that's exactly what we're hopeful for. The commission can make its decision as for Rush Island and securitization in this case, as we're, you know, is intended to be. But again, we don't know how many, you know, what if any harm will come, you know, in the future. I think Ms. Eubanks and/or others have mentioned certain remedies yet to be determined, you know, from the outcome of the litigation. There will be some amount of money, likely, it could be a substantial amount of money that comes with those remedies. depending on how Ameren determines to handle those costs and potential proposals for cost recovery from ratepayers. You know, if staff is of the position that it shouldn't be recovered from ratepayers, we want to be able to take that position and bring that, you know, forth in front of the commission.
Thank you. Those are all the questions I have. Any recross based upon bench questions from AARP or CCMO?
No, Your Honor.
Any recross from MECG?
No, thank you, Your Honor.
Any recross from the Office of the Public Counsel?
Thank you, no.
Any recross from Ameren, Missouri?
Just a little bit, Your Honor. Mr. Fortson, you understand, do you not, that Sierra Club was and I guess is a party to the district court litigation, right?
I do.
And you understand, well, let me back up. The company filed a motion protective order in the 2020 IRP when it actually did submit specific alternatives that assumed Rashawn would retire in 2024 because of an NSR loss, right? Let me rephrase the question.
Please.
In the 2020 IRP docket, the company filed alternative resource plans that assumed that it lost the NSR case and assumed that as a result of the loss of the NSR case, it would retire the plant in 2024. Did it not?
It did.
And that is in fact what has happened, right?
That's what's happened, yes.
And Sierra Club was Sierra Club was a party to the district court case, right?
Right,
Sierra Club was a party to the IRP, the 2020 IRP, right?
right.
And before it filed those scenarios, it asked the commission to enter a protective order to prevent really anybody beyond the Sierra Club lawyers who were actually or involved in the IRP case. In other words, not all the Sierra Club experts and people in the Sierra Club that are involved in the Beyond Coal campaign, all these other things, right?
Right.
Filed a motion for protective order to prevent Sierra Club from disseminating that information to the detriment of the company, right?
That's right.
And the commission agreed with that request and they entered the protective order, right?
They did.
And the reason is the company was concerned that it might be hamstrung or there might be issues caused in the district court litigation to its detriment
Mr. Lowry, you're testifying.
well, it is cross-examination, but
Go ahead.
I'll try to make it a little more concise, Judge. Was concerned that if Sierra Club had access to that information, being a party to the district court case, that it might be detrimental to the company's position in the case, right?
I don't remember what the reasonings the company offered, but I'm sure that's right.
And you understand why the company was concerned about that, right?
I do.
I think at the end of the judge's questions, you were talking maybe entirely about this transmission hold harmless proposal that Ms. Eubanks has. Is that right?
Hold harmless in general, yes.
And I think the judge was, based on Ms. Eubanks' testimony, was suggesting, well, Ms. Eubanks says that the alleged harm that staff alleges relating to those costs is more certain than maybe some of these other future alleged harms that the staff has been talking about, right?
I think that's right.
It's true, is it not, that in the 2014 IRP docket, in the 2017 IRP docket, in the 2020 IRP docket, in none of those dockets did the staff ever raise a concern or an issue or claim a deficiency in the company's planning relating to transmission upgrades, did it?
Not that I'm aware of.
When the company changed its preferred resource plan in 2022 to call for the retirement of Rush Island in 2024, staff didn't advise the company or the commission in any way that the staff thought the company should have been planning earlier or differently about these transmission upgrades, did it?
I believe that's true.
Would you agree that the transmission upgrades they can't actually be done until a retirement decision is made. MISO studies the impact at that time and then says what the transmission upgrades need to be?
I don't know exactly how that whole process works, really.
Do you agree the transmission system is dynamic and the conditions on it change from year to year based on plant retirements, other plant retirements, not just Ameren, Missouri, transmission upgrades that have happened, generation additions? Would you agree with that?
Seems reasonable.
If the company had done earlier planning around this, and if that planning suggested you could put in transmission upgrades for X, let's say X is less than what they actually cost, but the company was going to have to retire the plant earlier in order to put those transmission upgrades in at an earlier time at a lower cost, wouldn't that have necessitated retiring the plant earlier?
I don't know all the variables, and I don't want to speak for or go against, step on toes of anything that Ms. Eubanks said.
Well, you don't know is what your testimony is,
That's
right?
fair.
If Mr. Michael said that was the case, would you disagree with him?
I guess that depends. I don't know for sure, in taking into account all the variables and the circumstances. I don't know if I would disagree or not.
Well, so the truth is that you don't know whether or not putting transmission upgrades in hypothetically earlier at a hypothetical lower cost, you don't know whether that on a net basis would have been better for customers or not, do you?
I don't know.
Because if it meant that the plant needed to retire earlier and thus stop producing margins that flow back through the FAC to customers earlier, if those margins were going to be more than any hypothetical transmission cost savings, customers would actually be worse off saving a few bucks on the transmission upgrades and foregoing those margins. Isn't that right?
Judge, I object. I believe he's getting way beyond the scope of the commission questioning.
Sustained.
Judge, I'm going to stop my cross-examination at this point. I do just want to point out, because you asked a number of questions of Mr. Fortson about his testimony. I could probably go on for 45 minutes and establish facts that are already in the record in Mr. Michael's rebuttal testimony, and I'm not going to do that and burden the record with that, but I would encourage you, for balance on this issue, to certainly look at that.
Yes, I certainly will. Just because I mention a part of somebody's testimony, that doesn't open their entire testimony up to recross.
No, I understand that.
You have no further questions for this?
I do not. Thank you.
Any redirect from staff?
Yes. Going back to the discussion you had with the bench, you were talking about the kind of nebulousness around the decision points in this case and how they were broken up into issues. Do you recall that?
I do.
And would you agree that, well, let me rephrase that. Sorry, I'm in cross mode still. In your opinion, how many distinct decision points are there?
Distinct decision points as far as this case?
Yes, that culminated and had a changing, I guess if you look at it as a decision tree, is that the term? Would something like the decision-making process behind the 2007 and 2010 process projects be like a first part on that decision tree?
I'm going to object that this is beyond the scope of the bench's questions. I don't think you ask anything about the NSR permitting decisions at all. At best, you ask about the witness's opinion about whether the company had planned in its IRP in later years appropriately or not.
I was just trying to clarify because and I apologize if I misunderstood, but it seemed like that there has been some confusion on how staff and parties have thought if decisions were all together and you could view them as imprudent, or if certain ones could be viewed prudently and certain ones could be viewed imprudently, and then how that hold harmless interacts with it.
I did discuss that when discussing my confusion with the issue.
I didn't think that was the question she asked, though, but
Well, what was your question again? It kind of got lost when you hit decision tree.
And I could probably phrase it better too, which would help. I'm not going to be able to say it the same way, but it was essentially, would the decision-making process behind the 2007 and 2010 project be the kickoff of where this all starts?
same objection. If the criticism is we didn't plan for an NSR loss, we didn't even have an NSR case at that time.
That question does seem a little out of scope, so I will sustain that objection.
You were asked about, you had a discussion with the bench about if the IRP, no matter what time the IRP had planned, it couldn't have prevented the closure. Do you recall that?
I do.
Could an IRP that had incorporated closure earlier lead to different past plant investments?
Yes.
And you had discussions with the judge about the speculative nature of the harm from this. If no disallowances were made, what value would you find in addressing these kinds of issues for moving forward in future planning?
Can you help me with that a little bit, maybe?
Is there value to addressing this issue other than monetary value?
Addressing this issue or potential harm in future proceedings?
Or encouraging utilities to incorporate planning earlier decisions?
I mean, I think ultimately the outcome, that where we're at now, could definitely, lead to utilities taking certain things more into account going forward as far as planning to try and help mitigate any issues, any, that transition to a new plan. And a lot of this is, I will admit, sort of hypothetical, but maybe it leads to better planning.
And while you were explained a little bit about the IRP process, but did agree that there are speculative unknowns, I guess, at this point. But does long-term planning transition, it turns into implementation at some point? Would you agree?
What was the last part?
At some point, utilities, when you've reviewed IRPs, that long-term planning transitions into implementations of projects. Is that your experience that you've seen?
Sure.
And does that involve, do you usually see more firm details on that?
More firm details throughout the IRP planning process?
Better assumptions on cost or changes like site information, the more it's moved through the IRP process?
Can
Judge,
you
I'm gonna-
clarify this question for me? I'm not really understanding the question.
I'm poorly trying to, IRPs processes build on each other. And the sooner an IRP would consider a potential outcome, the more they study that, the next IRP and then the one after that, even if there's no building or construction, would have more assumptions, more cost, more information for parties and Ameren and whoever to evaluate and look at. So we would know the potential, we would know sooner the harm from anything, the how this court decision could impact planning decisions in the 2020s prior and prior. So it's trying to work into that chain of questioning.
Are you saying that the IRP decisions could influence the court decisions?
No, but if the court decisions were,
Incorporated into the
The IRP.
ICO.
yes.
All right. You can answer that question. I asked questions about how the IRP and the court decisions dovetailed.
Sure. I think anytime that, we get further through any process, learn and understand, additional details, any of that additional knowledge and more firm numbers or estimates adds value to any plan, including, integrated resource planning. Any assumptions you can more so firm up is going to, help help for that planning and help, the company, the stakeholders understand and rely on that planning more. The more solid information you have.
I'm going to turn to your discussion with counsel for Ameren. Do you remember covering discussion of the 2020 IRP
Yeah, we talked about it.
and that timing?
Yes.
When did Ameren lose the first case, first district court case?
It's been a lot of dates thrown out. Was it 2017? I
Right.
think was the initial decision.
You also had it's around that date. I actually don't have it written down myself either. You had a discussion about Sierra Club's impact on being both a party to the district court case and parties to cases before the commission. Do you recall that?
Yes.
Are there ways to address confidentiality issues and still properly plan for the future?
I would assume so, yes.
You were also asked about staff's past filings in IRP cases. Do you recall that?
I do.
How do staff's views incorporate changing market, economic, or operating conditions?
Can you say that again?
How do staff's views incorporate changing market, economic, or operating conditions?
As far as
Over time.
staff's views that they change over time?
So, and, okay, yes. So views can evolve, and would you agree that they should evolve based on new information, new market conditions, new economic conditions, or new operating conditions?
Absolutely.
Do you recall, was there a Rush Island investigation done by staff prior or after the IRPs Mr. Lowry spoke to you about?
At some point, yes, there was.
In your opinion, could that have impacted staff's view on the situation?
Sure.
And do you recall if transmission costs were discussed in that?
In the investigation? I don't recall. It's very likely, but I don't recall.
Okay. That's all I have. Thank you.
Mr. Fortson, you may step down and you're excused. Next witness is Ameren, Missouri's. Ameren, please call your next witness.
We call Matt Michaels to the stand.
I believe I've been saying Mitchell's for 3 days now, so.
I tried.
I'm sorry, Mr. Michaels.
I think I subtly once mentioned his name, but you didn't pick up on it, which is fine.
There's a lot I don't pick up on.
Oh, there's a lot to pick up on, so.
Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Ameren, go ahead.
Judge, this is Mr. Michaels. He's already been, he's sworn before and appeared before. This is his last time on the stand, so I'd like to offer Exhibits 14. There's a confidential and a public version. Exhibit 15, there's also a confidential and public version, which I understand you would provisionally be admitting. And then Exhibit 16, his sir rebuttal, which I also understand you would be provisionally admitting.
That is correct. Thank you. Any objection to admitting Exhibit 14C or P onto the hearing record?
Judge, this is Jeff Keeble jumping in from outer space. I make a response there that Ms. Murders may not be aware of.
Say that again, Mr. Keeble.
I was just going to say Ms. Murders may not be aware of this, but because she wasn't involved in the thing Monday, in the hearing Monday, but Mr. Larry mentioned several of Mr. Michael's exhibits have been objected to and or subject to motions to strike, and I assume that when he says provisionally admitted, that's what he's referring to, and that this is not an attempt to forget about those motions to strike that are hanging out there.
Mr. Keeble, we've already admitted something provisionally today. I believe Ms. Mers is quite aware of the motions to strike. All right. Exhibits 14C, 14P, those are the direct testimony of Matt Michaels. There's Exhibit 15C and 15P, which are the sir rebuttal testimony of Matt Michaels, to which there has been a motion to strike.
Correct.
And I authorized the company to file sir rebuttal, but that is also subject to that motion to strike. If the motion to strike is granted, obviously the sir rebuttal disappears. So is there any objection to admitting his direct testimony onto the record and the sir rebuttal testimony and sir rebuttal admitted provisionally?
Not as admitted provisionally as we've been doing with the other ones.
Yes,
motion to
subject,
strike. Yep.
subject to the motions to strike.
Right.
All right, I hear none. Exhibit 14C and P, Exhibit 15C and P, and Exhibit 16. 14 is admitted, 15 and 16 are provisionally admitted. Go ahead, Ameren. Or did you tender your witness?
I will now, Judge. Thank you.
Any cross-examination from MECG?
No, thank you, Your Honor.
Any cross-examination from AARP, and I'm just going to refer to Consumer Council of Missouri as CCMO, if that's okay.
That's fine. Yeah, I have no questions.
Thank you. Any cross-examination from the commission staff?
Yes. Good morning.
Good morning.
Do you recall yesterday that we spoke about Ameren, Missouri's load and planning reserve margins? And in that discussion, you agreed in the 2020 IRP, summer load and planning reserve margins were at their lowest. The lowest point in the future was 7,339 megawatts.
That sounds familiar.
And were you here for Mr. Burke's testimony?
I was not.
If he discussed a 7,800 megawatt summer load and planning reserve margin, would that surprise you?
No.
And Ameren's load does not go down that much year to year, correct?
That's correct.
And were you aware that since at least as early as NERC's 2020 to 2021 winter reliability assessment, that the MISO region was identified as at risk for extreme weather?
Yes.
And does the commission's IRP rule require the company to consider extreme weather?
Yes, it does.
Did you respond or provide any information in staff's investigatory docket on proceeding this case?
I don't know whether I did or not.
Did you attach a data request to your testimony in this case from that study or that workshop? Do you recall?
I believe I did, and because that data request was referred to in one of the testimonies to which I was responding. I don't remember which.
Okay, so it was I was just trying to clarify, it's your rebuttal testimony. If you want to try to pull that up to follow along.
What page?
Would have been, do you recall that schedule? I apologize, I don't have the schedule number. In your 2021 analysis of Rush Island retirement versus retrofit analysis, did you change any carbon pricing from the 2020 IRP?
No.
And in that same analysis, did you make any changes to natural gas pricing from the 2020 IRP?
No.
And in that analysis, did you make any assumption changes to reflect the change in social, environmental, and governance outlooks from the 2020 IRP?
Could you repeat that, please?
In your 2021 analysis of Rush Island's retirement versus retrofit, did you make any assumption changes to reflect changes in either social or environmental, governmental policy outlooks from the 2020 IRP?
No, those are things that we normally review as part of our annual update process. We had determined that the ranges that we had used in the 2020 IRP were still valid. So at the time that we did the 2021 retire versus retrofit analysis, we had recently determined that those were still good.
Did you update assumptions you did update assumptions on the cost that to operate Rush Island in the future and the assumed cost of the scrubbers in that analysis, correct?
I believe so, yes.
And did you use the Kenneth Snell expert FGD report?
I believe that was the source for one of the assumptions that we used, since we used several levels of assumptions for cost for scrubbers.
Did you use other studies?
Yes, although I can't remember which ones at this point.
Okay, I think some of those names might be confidential anyway, so. I don't think this is, but I'm sure Mr. Lowry will stop me if it is. Was that other study done by Black and Veatch?
I honestly don't recall at this point.
Okay. And do you recall if it was done by Shaw?
I don't know. We had done the analysis in 2021. I did a refresh analysis for my rebuttal testimony So we were looking at lots of different estimates at different points in time, and I don't recall now which ones were used when.
And was 2021 also the date of the transmission work papers provided? Are the transmission studies provided that were used in the analysis?
So are you asking me, when had the transmission studies been performed that were used as a basis for the assumptions in the retire versus retrofit analysis?
Yes.
They had been done since the time of the appellate court's decision in August of that year, so they were fairly new. Had been done as part of the MISO process and performed by transmission planning.
Do you recall in your provisionally accepted sir rebuttal discussing Ameren, Missouri's portfolio transition risk that was ordered out of the 2020 IRP?
I think I know what you're talking about, yes.
Was that at the same time, done at the same time as the announcement of Rush Island's retirement?
It was filed the same month.
And was the commission informed in a footnote?
I don't know.
I think that's all I have. Thank you.
Any commission questions? Chair Hahn, please go ahead.
Good morning, Mr. Michaels.
Good morning.
I spent a lot of time this morning talking about the IRP process, and so I want to talk to you again about that. In your testimony, you say that the commission found the company's 2020 IRP was in compliance with IRP rules. Can you give me a summary of what it means to be in compliance with IRP rules?
Sure. It means that the company has followed the specific provisions in the IRP rules that were promulgated by the commission most recently in 2011. So that's at bottom what it means.
To your knowledge, what happens to the IRP after you file it with the commission? Does staff undertake a review? Tell me what happens in that process after it's filed?
Sure. So once the IRP is filed, staff and other parties have, I believe it's 150 days to review the filing, to ask data requests. We often have a meeting after the filing and before the 150 days is up, usually fairly soon after the filing, to kind of walk through the filing, to orient staff and other parties to it, what's in it, where to find things, and also to ask questions, and also to invite them to reach out, whether it's through formal data requests or informally just talking to us if they have questions. And so during that time, they're able to perform their discovery and ask questions, and then file reports that allege deficiencies, which are violations of the rules or alleged violations of the rules, or concerns that they have that may affect the performance and the selection of the resource plan, but not rise to the level of a deficiency. Following that, the parties have 60 days to work with us on resolving any issues that are identified, and then we make a joint filing at the end of that 60 days to indicate what issues we have resolved, and then the company responds to any issues that remain unresolved. Those go to the commission, and then the commission makes a determination as to what happens next.
Okay. I acknowledge this may be a legal question, but to your knowledge, is an IRP filing considered a contested case before the commission?
No, I don't believe it is.
So if there were potentially a deficiency, or staff may potentially have a different opinion of the company's planning process, is that ever, how would that be brought to the commission's attention for consideration, or would it ever be?
It would be in the joint filing if it's resolved, and it would be, I think, also listed in the joint filing as an unresolved issue, and then also in the company's response.
To your knowledge, generally, as a whole, the commission does or does not endorse a company's IRP? Or we do or do not issue an order approving it?
Not approving the IRP. There is the option for the commission to acknowledge the IRP as reasonable at the time that it was filed, if it also finds that there are no deficiencies.
Okay. In your testimony, you write that staff has apparent hostility to the IRP process in general, characterizing it as a little more than an academic exercise. You also say that the commission is very clear that it has a high emphasis on the IRP process. Do you think that it's possible that it can be both an academic exercise and also very important? The two are not mutually exclusive.
I would agree with that.
You also say there could be a misalignment between the commission and its staff regarding the importance of the IRP. But if you think that the two are not mutually exclusive, do you then also think that potentially there's not a misalignment, but the two can coexist?
I think the two can coexist. My contention is that staff in recent cases seems to be suggesting that the IRP process isn't important, that it's not just that it's an academic exercise that is important, but that it's not important. This has come up in several recent cases.
In this case and others, Ameren has used the IRP process in some ways to justify their position, correct?
Correct.
I'm also summarizing here, but let me know if you agree or not. The staff is also using the IRP process in this case to justify their position, correct or no?
I think they're using the existence of the IRP process as supportive of their position, yes.
Okay, so both parties are using the IRP process to support positions, though different positions, yes?
Yes, and I think there is a distinction in how those are being used, one being the analysis, the results, the considerations themselves, and the other being the existence of the process.
Understood. You state in your testimony that staff offered no suggestions for improvement. I think it's in relation to the 2020 IRP. Is that something that staff would typically do?
It has in the past.
How recently? Just curious.
Oh. It's hard to put a time frame on it. I'd say it was pre-pandemic, if I can isolate it that way.
Well, this world has certainly changed, especially utility world since then.
Yes.
Okay. I don't think I have any further questions. Thank you, Mr. Michaels.
Are there any other commission questions? I hear none.
Judge, this is Nathan Williams for Public Counsel. I haven't had an opportunity to conduct any cross yet.
Did I skip over you, Mr. Williams?
I believe so. I don't anticipate extensive questioning, but I did have a couple, and Actually, they're along the lines of what Chair Hahn was asking.
Well, I apologize. I did not intend to skip over you. Please, go ahead.
Good morning, Mr. Michaels. There's been a lot of discussion about the integrated resource planning and, well, my first question is, does Ameren, Missouri do any planning, resource planning aside from the resource planning it does for purposes of the Chapter 22 resource planning requirements the commission has?
I think it's all under the IRP umbrella. There might be analysis that we do that ultimately end up in the integrated resource plan that may or may not have been formally part of it, but once we get to the IRP process, we're bringing that together.
Was Ameren, Missouri doing any NSR litigation contingency analyses relating to resource planning that prior to when it showed up in resource planning filings before the Missouri Commission?
Can you put a date on that for me?
Let's say 2017.
2017. So when we did our IRPs in 2014 and 2017, and this was discussed earlier, we avoided looking explicitly at potential NSR outcomes, partly because we just didn't know what the range of possibilities might be. Certainly we would not have anticipated prior to the district court's initial order that that lavity mitigation would be part of that order. That's not something we would have been able to anticipate, but the other reasons are also things that were discussed earlier with respect to Sierra Club's involvement in both the IRP and the NSR litigation. And so we wanted to make sure that we weren't doing anything that was going to, put the company and its customers at risk in the litigation process with what we did in the IRP. You heard Mr. Fortson talk earlier about, the retirement dates that we analyzed in the 2014 and 2017 IRPs. We did look at a retirement in 2024. And he does cite the reasons which the company did list, which were true at the time for the selection of 2024 as a retirement date. But what wasn't listed in the IRP was also that we had in mind that could be the timing of when a potential remedy may have to be put into effect. So even though it wasn't explicitly stated in those IRPs, it was certainly something that we had in mind along the way. So when we looked at retirement in 2014, in 2017, what we found in 2017 was that retirement would not result at that point in a need for, or in an imminent need for new resources. It would be out in the 2030s. What we found in 2014 was that there could be a need for new resources if the Noranda load remained on the system. And so, as we all know, that turned out a little bit differently. And I think we even knew at the time in 2014, because there was a complaint case that Noranda had brought, that might not be load that we need to plan for in the future. So while we weren't always explicit about the planning that we were doing related to potential NSR outcomes, we were thinking about it as we were putting together our IRP analysis.
So what's disclosed in your integrated resource plan filings doesn't necessarily include all of the factors you took into consideration when you did your resource analyses?
Well, it was certainly reflective of the factors that we considered, but as I said, we always also had in mind that that may mesh with the potential timing of a remedy in the NSR case, and that retirement may be one of those options.
And the remedy you were referring to with regard to Labadee, that was putting on some emissions control equipment?
Dry sorbent injection, correct.
And what impact would that have on the availability of Labadee, if any, or power output?
It would not have necessarily an impact on Labadee's continued operation, although operating the dry sorbent injection system would have some impacts on the net output of the plant. It would also result in incurring some significant costs as well.
Thank you. No further questions at this time.
Since I had skipped over public counsel, we're going to go back to, I believe we're on bench questions. I do have a few questions for you, Mr. Michaels. I haven't skipped anybody else, have I? Okay, thank you. For my questions, I think we're going to have to go in camera.
Okay.
So let's go in camera. Any recross from MECG?
No, thank you, Your Honor.
Any recross from AARP, CCMO?
No, thanks, Your Honor.
Any recross from the commission staff?
Just very, very briefly.
And remember, we are out of in camera, so
Yes.
do not ask
I will.
about specific numbers.
Try to avoid all numbers, except for this first one, but they're not confidential ones. Do you recall discussing with Chair Hahn the IRP process?
Yes.
And do you recall stating that you guys provided the filing and then staff and other parties had 150 days to review?
Yes.
How many pages and schedules are usually in an IRP filing?
It's hundreds.
And work papers?
The work papers are pretty voluminous because of the nature of the analysis.
You commented in that discussion with Chair Hahn about some recent cases and how you characterize staff's view of things in them. Do you recall?
Yes.
Were those cases CCN cases in which staff opposed Ameren being granted a CCN?
One of them was.
You also discussed with Chair Hahn the value of an IRP, if it's an academic exercise, if it's informative, can it be both? Do you recall this?
Yes.
Would you agree that the informative nature of the IRP depends on how detailed or specific that information is?
Sure.
And you had, again, trying to avoid numbers, but you had some discussion with the judge regarding the timing of, I think I can say, transmission study. Do you recall that?
Yes.
And you believed it was completed in fall, November 2021, was that your
Yes.
statement? And do you recall when Ameren filed its change of preferred plan?
It was June 2022.
And do you recall when, scratch that question. For those studies, do you know it, sorry, I'm trying to just think out loud. You said it was after the appellate court case decision, correct?
What was after?
The transmission studies were completed?
Yes.
When were they issued or started?
When were what issued?
The transmission studies, did you begin them at that same year, or?
Yeah, I believe that was all done following the district court decision.
And do you recall what year Ameren's first the first district court opinion came down in?
I believe it was 2017.
And do you recall when the circuit court that affirmed it, that opinion came down?
I believe that was August 2021.
You included scratch.
Any recross from public counsel?
No, thank you.
Any redirect from Ameren, Missouri?
Yes, thank you, Your Honor. I'm going to try to just go in reverse order primarily. Hopefully won't jump around too much. You were asked some questions by Ms. Mers just now about how many pages an IRP filing is. Do you recall that?
Yes.
You said hundreds, I think. Is that right?
Yes.
What familiarity does staff have with a given triennial IRP filing, if any, before it's filed?
So we usually have a workshop at some point after we've developed our assumptions and before we complete the analysis of resource plans. That's actually required by the IRP rules. And we also provide drafts of certain chapters required by the rules to staff and the other parties. Those include things like the load forecasting, the cost of supply-side resources. We use the demand-side resources potential study as a stand-in for the chapter on demand-side resources. Also, transmission and distribution assumptions. So those are provided usually about, I'll say 5 to 6 months in advance of the filing. In the case of the 2023 IRP, we also met with staff and Office of Public Counsel to kind of go through a preview of the filing and answer questions.
How do, you provide a number of chapters and information, I think you said. How does that information change, if it does change very much, between when you provide those drafts and when you file the IRP? I think you said maybe 5 months later.
Usually very little, if any, in the draft chapters that we provide in advance.
Your IRP work, I think there were questions and issues came up about your work papers, I believe, when Ms. Mers was asking you questions. You remember that?
Yes.
What familiarities does staff and the other parties of the IRP have with the company's IRP work papers and modeling?
It's hard to know. I do know that from IRP filing to IRP filing, the structure doesn't usually change much, and certainly we've been using the same IRP model that calculates things like revenue requirements and rates that we use to support our decision for selection of the preferred plan since 2014.
I guess you don't know to what extent staff does or has dug into those models in the past. Is that fair? You probably don't
I
know
would
exactly.
Object to that as speculation.
I didn't ask them to speculate as to what they know. I asked
Would you
them.
rephrase your question for me? I mean, would you let me know what your question is, please?
Yeah, I'll try to. Do you know what level of familiarity staff has with those models and work papers? You know you've provided the same ones, but do you know what level of familiarity they have with them?
It's hard to know for sure.
I'm
Do you-
fine with that question.
Do you have an opinion about whether, assuming staff actually does look at the IRP stuff over the years from IRP to IRP, do you have an opinion about whether when staff gets a new set of work papers and a new IRP, they could understand what they're being given that they've seen it before?
I think a lot of it is sort of similar format. The numbers change, but the structure of it more or less remains the same.
Ms. Mers asked you questions about the transmission study that led to the confidential figure the judge asked you about. I'm not going to mention, but you remember what that was, right?
Yes.
And then she asked, which the record reflects this, when the remedy or when the liability decision was made by the district court, when the remedy decision was made, right? 2017, 2019?
Yes.
Do you have an opinion about whether looking at the transmission system at that time would yield the same results or different results, or might at least yield the same or different results than if you look at it later?
I would be shocked if they were the same between any 2 points in time in terms of analysis and results.
And why is that?
It's for things that I mentioned in my testimony. I believe it was Sir rebuttal testimony. The system is always changing. There's changes in transmission infrastructure. There's changes in resources, either additions or retirements. The nature of the additions has an effect as well. And so if you do the analysis at one point in time, you're very likely, almost certain, to get a different result than if you did the analysis at a different point in time.
The MISO Y process, where MISO, where the utility says, we've made a decision, we're going to close this plant, we're going to close it this time.
I would object. I don't believe the MISO Y, we've talked about district court opinions and transmission studies, but I don't think the MISO Y process has been part of anybody's questions.
Well, the MISO Y process, Judge, is the process that by which transmission cost estimates are actually finally determined. And the implication of Ms. Murr's questions were that about the dates of the court opinions were, well, couldn't have you studied it at a different time? And I'm just going to ask some questions to establish what the timing actually, how it actually works in terms of the timing when you can actually study it and get an estimate that reflects the date that you're actually retiring the plant.
Say that again, please. That,
Well, let me just explain the process, and then you can, a little bit, obviously this is just an explanatory. I believe Mr. Michaels will say that the Y process doesn't start until you make a retirement decision, you pick a retirement date, and it's only then at that time, under the transmission system conditions that exist then, can you actually get a higher quality, good estimate of what the costs are going to be. And the implication of staff's questions is, well, why didn't you plan for this earlier? Why didn't you study it earlier and you might have got a better estimate? And the point is, I'm just undermining, frankly, the point that they're making by having him explain what the actual process is.
The questions today have been about Ameren's own studies, not about any studies that MISO have done.
But Judge, the actual costs of these projects are based on actual MISO studies. And they're basically saying your estimates weren't any good, and so cap the recovery based on your estimates that weren't actually the MISO studies, because the actual work that had to be done based on the actual studies may have cost more.
bear with me just a moment. I remember Mr. Michaels briefly mentioning that something occurred prior to the MISO retirement process.
He actually did bring up the task.
I'm going to let you ask your question, and I'll give it whatever weight it is due.
Thank you, Judge. Now I got to try to figure if I can formulate an intelligent question here, Mr. Michaels. How does the company ultimately figure out what transmission investments are going to be needed and are going to cost when a plant retirement happens?
It's really to go through that MISO attachment Y process. So the company has to submit its attachment Y application to MISO, and then MISO, I believe, under the tariff, has 6 months to review, perform the analysis, and provide the results.
Can you do that hypothetically when you haven't decided to retire the plant?
I think there is a Y2 process where you may be able to get an indication, but it's not necessarily going to give you the same answer that you get if you go through the full attachment Y process.
Is there an advantage to actually doing the full Y process close in time to when the retirement's going to take place?
Certainly. Yeah, I mean, you will have a better sense that the estimates for the costs and the equipment needs are accurate to what is going to be needed at the time the plant retires.
Okay, thank you. The chair asked you a number of questions, really sort of about the IRP process and maybe its weight, and questions about what staff does or does not raise. Do you remember those?
Yes.
Why, well, if it would be important, if you think it would be important, why would it be important for the staff to raise their concerns, their issues, with your planning process as part of the IRP process?
It would just give us better feedback, maybe a better indication of thoughts that would help us to improve our planning in a more timely fashion.
Would you be able to take, if staff has concerns about the level of detail or the quality of the information in IRP, would you be able to address those as you move forward in time if staff doesn't let you know about those?
We can't address what we don't know.
I think the chair asked you some questions about, this misalignment statement that you made and whether both things could be true. Do you remember that?
Yes.
In your opinion, is staff using the IRP in this case in the way that Ameren, Missouri has used it in, for example, CCN cases?
No. This is the distinction I was drawing between relying on the process, the analysis, the results to form conclusions about the proper path for future resources versus mentioning the process as a process.
Bear with me just a second, Judge, please. You were asked some questions by Ms. Mers during her first round of cross about, I think she asked you a series of questions about what assumptions from the 2020 IRP were updated for the late 2021 retire versus retrofit analysis. Do you remember that?
Yes.
And just to get the timing right, the 2020 IRP was filed in the fall of 2020, and it was examined and litigated, I guess you would call it, throughout 2021, or a good part of 2021, right?
That's correct.
The late 2021 retire versus retrofit analysis is not the only analysis that you have done of the retire versus retrofit question, right?
That's correct. Correct.
Am I correct that you essentially updated all the assumptions from the 2020 IRP for that later analysis? You actually used the 2023 IRP assumptions?
Yeah, I alluded to it earlier in response to one of the questions that we performed an updated retire versus retrofit analysis using the 2023 IRP assumptions. I included the results in my SIR rebuttal testimony, and that's what gave rise to about $1 billion in savings for retiring versus retrofitting.
Did the later analysis suggest that your December 2021 analysis was right or wrong in terms of the decision it led to?
It established that not only was it right, but it was even more beneficial than we had originally determined.
And then I think the last inquiry I'm going to ask you about is Ms. Mers asked you about Mr. Burke's statement. I think that he thought our peak summer load was about 7,800 megawatts, and I think you said that didn't surprise you that he said that.
Right.
And I don't know that Ms. Mers said it this way. I can't remember exactly, but I thought she asked you a question about that suggested that the 7,800 megawatts was both load and the planning reserve margin. Is that how you understood the question?
Yeah, I think that's right.
That's right that she asked that question, or?
That's the way I was interpreting it.
Okay. And does the 7,800 figure, does it include the planning reserve margin, or is that just the load?
I don't know since that was a number that I guess Mark Burke mentioned while he was testifying, but it sounds like a number that includes the planning reserve margin.
Irrespective, the exhibit, she used, I think, Exhibit 118, it has that, it maybe has a figure that's in this ballpark on it for a peak load. That exhibit also shows what the capacity position is, including the PRM, right?
Could you repeat the question?
Exhibit 118 shows a peak load. It may show it may show peak generation, but it also shows the company's capacity position each year, whatever the load is, and the PRM versus the available resources, right?
That's right.
That's all the questions I have, Judge. Thanks.
Thank you. Mr. Michaels, you can step down. And you are excused. It seems like as good a time as any to take about a 10-minute recess. So it is currently 10:38. Let's all come back at 10:50. And I believe we're now on to issue 6, which is net plant. What is the net plant and service balance of the retired Rush Island plant? And that is for both A, if retired September 1st, 2024, and B, if retired October 15th, 2024. I believe the first witness in this case is Ameren, Missouri. So Ameren, you may call your first witness. I intend to, I'm not breaking A and B up in terms of witnesses. If you're a witness and you're up for A, you're also up for B. So Ameren, call your next witness.
Mitchell Lansford.
Mr. Lansford? If you'll come on down, I'll swear you in again. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? I do. Please be seated. Ameren, go ahead.
I do not believe this is the first time Mr. Lansford's been on the stand, so I believe all the corrections have been made to his testimony. It is also not the last time he's going to be on the stand, so I will not yet move for admission. I will instead tender him from cross-examination.
Thank you, Ms. Tatro. Any cross-examination by MECG? MECG is not currently in the room. Is there any cross-examine? Well, AARP and CCMO are not currently in the room. Is there any cross-examination by the commission staff?
One moment, Judge. Nothing from staff, Judge. Thank you.
Give me your name, please.
Yes, Judge. Well, thank you, court reporter. My name is Travis Pringle. This is Keith Majors. He's going to be one of our witnesses.
Sorry, Mr. Pringle. Ms. Mers wasn't here earlier. We have had a different court reporter every day, so when we have one, please update your information.
I am Adam Court. My information is the same as Ms. Mers, but
You said no questions from OPC?
Actually, I hadn't been asked yet, but I
Oh,
don't have
well, I don't want to skip
anything.
over you again because that would be terrible. So I got caught up in the court reporter thing. So any cross-examination from public counsel?
Nathan Williams for Public Counsel, no, thank you.
Any commission questions for Mr. Lansford? Go ahead, Commissioner Holzman.
I just want to better understand, we're looking at 45-day difference and about a $5 million difference in estimate. What is that, help me understand what that accounts for. I mean, the plant's not in operation right now, correct? I mean, what was it? Oh, it still is, okay. So that 45 days, if you did the math, then you could extract how much the value is on a daily basis. Would that be accurate?
That's right. So that $4 to $5 million represents the depreciation on the plant that would occur from September 1st to October 15th.
Okay. And is October 15th, is there a preference in the two dates as far as the company's position?
I think our preference is to securitize the balance that exists upon retirement, and exactly when the plant will retire is subject to some of the MISO processes.
I see.
So we're waiting to sort that out.
So the A and B is not really in your control?
That's correct.
Okay. All right, thank you. My questions.
Thank you, Commissioner. But just to clarify for the Commissioner, there's an outside date by which the plant has to close, correct?
That date, my understanding, is October 15th, yes.
And that's the date the judge ordered it.
That's exactly correct.
Thank you. Any recross based upon commission questions? MECG was not in the room for cross-examination. Do you have any recross?
no, thank you, Your Honor.
Any recross based upon commission questions from the staff?
No, thank you, Judge.
Any any recross based upon commission questions from public counsel?
Thank you, no.
Any redirect from Ameren, Missouri?
None, thank you, Your Honor.
Thank you for testimony, Mr. Lansford. You may step down. And Ameren, do you have another witness for this? No, I believe the next witness is a staff witness. Staff, you may call your witness.
Thank you, Judge. Staff calls Keith Majors to the stand. And Mr. Majors has also been on the stand already. Corrections have been made, and because he will continue to take the stand, I will not be entering his testimony at this time, but do tender him for cross.
Thank you, and thank you for being aware of what we were doing with the testimony. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Sorry, didn't mean to catch you off guard there. Please be seated. Go ahead, staff.
Yes, Judge, at this time I tender Mr. Majors for cross-examination.
Any cross-examination from MECG? Let me refine my place real quick. There were no questions from MECG. Any cross-examination from public counsel?
No questions at this time, thank you.
Any cross-examination from Ameren, Missouri?
None, Your Honor.
Are there any commission questions for this witness? Yes, Judge. Commissioner Holzman, whenever you like.
Thank you, Judge. Good morning.
Good morning.
So staff has 468.9 million, and OPC has 442.8 million. And that's a difference of 26.1 million. Can you speak, and I'll ask OPC the same question, but I'd like to get staff's perspective. Can you speak to, just on the surface, you know, I understand that that's the delta of the disallowances that OPC is recommending. Have you had a chance to look at their math and you know, see how they arrived at that? Do you have an opinion or a testimony on their numbers and why there's a difference here?
Unfortunately, I don't. I wish I did. I went back and looked at the last numbers in the last rate case and did more or less just a sanity check comparing Mr. Lansford's numbers that staff also used as of October 15th. So at this point, I don't have one. I could certainly run those numbers for you and have them at some point during the
Okay,
week.
let me ask you another way. I mean, staff's numbers at 468.9 are identical to the company's numbers. You feel like your math and the facts that you used to come up with that was an accurate assessment as you see it?
Well, the numbers were derived from Mr. Lansford's testimony, which was derived from the plant records in the general ledger. So, in comparing that to the amounts in the last case that were included in plant service, those seem to be a accurate representation of the actual plant values. And keep in mind that they are projected, but the actual plant values that we used were as of June 30th. And so we projected out, Mr. Lansford projected out, we checked those calculations through October 15th. And that also, I'm not entirely sure, you'd have to ask Mr. Robinette, but in the final plant numbers, the company did reflect the transfers to other plants and also additions and the removal of the land, the value of the land, since it's not necessarily going to be retired and securitized, it's land. And so I don't know if Mr. Robinette, you'd have to ask him if it reflects the transfers to the other plants.
Okay. All right. Thank you, Judge.
Thank you, Commissioner. Are there any other commission questions? I believe you already answered my question, so. Any recross based upon commission questions from MECG? Any recross based upon commission questions from the commission staff?
It's our witness, so no cross.
I am sorry. Sometimes it seems like every day it's something. With the online, it was the mute button that I couldn't find. Today, I am looking at the wrong line for my witnesses. So thank you for bringing that to my attention. Any recross based upon commission questions from public counsel?
No, thank you.
Any recross based upon commission questions from Ameren, Missouri?
Yes, thank you. Mr. Majors, Commissioner Holzman, see, I can't talk this morning either, asked you a question at the very end talking about the staff and company numbers, and had you reviewed them, and you mentioned in your answer that there was some projected numbers in there, and how you had come to get comfortable with the numbers. Do you remember that conversation?
Yes, I do.
Is it also true that the statute requires that number to be reconciled as part of this process as it moves forward?
I'm not an attorney, but my understanding of the statute, yes, that's correct.
Okay. No further questions.
Any redirect from staff?
No redirect, Judge. Thank you. Just ask that Mr. Majors be excused for this issue.
You may step down, Mr. Majors. Thank you for your testimony. I believe the next witness is public counsel. Public counsel, please call your witness.
John Robinette, please.
Mr. Robinette, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Public
What-
counsel?
Thank you. Sorry. What is your name?
John A. Robinette, and Robinette is spelled Robinett,
And how is John spelled?
with an H.
By whom are you employed and in what capacity?
I'm employed by the Missouri Office of the Public Counsel as a utility engineering specialist.
Did you prepare rebuttal testimony that includes 4 schedules that has been marked for identification as Exhibit 206 that
Yep.
has been pre-filed in this case?
Yes.
Would you make any changes to that testimony for it to be your testimony here today?
I have no edits.
Is it in fact your testimony here today?
It is.
With that, I offer Exhibit 206. It's confidential and a public version, and I'll point out that although Mr. Robinette is listed on another issue, that is one that is not contested.
And so you would like to go ahead and move for admission at this time?
Yes.
I'm just asking because my last number is 204. Was there a 205 I missed?
Mr. Payne's rebuttal testimony?
Thank you.
Your Honor, if I may?
Yes.
It appears to me that Mr. Robinette is testifying on decommissioning and materials and supplies, and I thought there was some issues with that, so I'm not sure that that's a correct statement.
Did I miss him?
Issues 11, is that 11? I can't read from here. 11 and 12.
I apologize then. I'll not offer his testimony at that exhibit at this time.
Okay, I will hold on that.
But I will tender Mr. Robinette for examination.
Okay. Any cross-examination from MECG? Any cross-examination from the commission staff?
No, Judge. Thank you.
Any cross-examination from Ameren, Missouri?
Yes, thank you. Good afternoon, or good morning.
Good morning.
So, Mr. Robinette, I want to make sure we start off on the same page with your recommendation here, and OPZ's position on net plant is not to include any amount invested at Rush Island after the December of 21 decision to retire. Is that a fair summary?
Yes, that's based on the depreciation study carried forward. I did not put any additions or retirements in after that point.
And ultimately, in the position statement that OPC filed in this case, that number was quantified at $27 million. Is that right?
I think the difference is roughly 27 million, yes. But
Okay. Do you have any idea of the average level of rate base investment that's made at Rush Island in, let's say, 2018 through 2020?
I'm going to object to that question as vague and that average over what?
Let me rephrase. Do you know how much rate base investment was made at Rush Island in 2018?
as we sit here, no.
Do you know how much rate base investment was made at Rush Island in 2019?
No.
Same question for 2020.
No.
Same question for 2021.
No.
Same question for 2022.
No.
I guess I have to ask the last one. Same question for 2023.
I mean, between 2022 and 2023, it's roughly the 27.
But you don't have any idea of whether or not that is more or less than the level of investment in the previous years.
No, I don't.
You didn't ask any questions about that?
No, I did not.
Did not issue any data requests requesting that information from Ameren, Missouri?
I don't believe I did, no.
Did you go back into previous, Ameren, Missouri has filed previous rate cases?
Yes.
Didn't go back into any of the work papers in the previous rate cases to see what the investment level was for Rush Island in previous years?
I would disagree with that because I built from the depreciation study in 21.
So you looked at work papers and documents from a previous rate case?
Yes.
But you didn't look to see what the amount of investment per year, rate-based investment per year was at Rush Island in the cases you had before you?
What do you mean by cases before me? You're talking the previous cases going forward, like an annual investment?
Yeah, let me rephrase and make sure I'm a little more clear. So in order to come up with the depreciation numbers that you moved forward, what did you look at?
I took the plant and reserve values from the depreciation study.
From what case?
I believe it's
The 22?
220337.
All right, so you
And
have
then-
I apologize, go ahead.
And then I would have built in the depreciation rates that were ordered from that period and tried to put them in when they became effective to build out what the annual expenses would have been to bring up the reserves out to the projected retirement date, of which I actually went further and did 4 potential retirement dates in between.
Right, I understand that. So you had documentation from the 220337 case in front of you. Did you look to see how much investment had been made, capital investment had been made at Rush Island during the test year for that case?
No.
You could have done that, yes?
Yes.
Do you know what projects were done at Rush Island that constitute the $27 million that you're recommending disallowed?
No, I don't.
Did you present any evidence that it was unnecessary to spend money at Rush Island after the retirement date?
Could you rephrase that?
Sure. Your testimony is that you did not include any additional capital investment made at Rush Island after the December of 21 decision to retire the plant, correct?
Yes.
What is your reason for not including that $27 million?
So I basically expected minimal investment going forward after a decision is to retired. You're not going to spend a whole lot of money to keep something running.
Define minimal investment for me.
I don't know that I can. I mean,
And you-
it's up to the utilities' decision of what minimal investment is.
And you don't know what what a normal level of investment at Rush Island is, correct?
I don't know the annual, I don't have an average of the annual spends recently, no.
Because you didn't ask.
Correct.
And that's your only reason, is that the amount should be minimal. That's your only reason for justifying not including the $27 million in the securitization.
Right, I mean, minimal investment to keep it running until the end.
Do you know what margins were generated at Rush Island in 21?
I do not.
Do you know how much were generated by Rush Island after 2021?
No, I do not.
And you didn't ask that question?
No, I did not.
Okay. Is it possible that some of the investment that was made at Rush Island was necessary to keep the plant operational?
Absolutely.
But you don't know because you didn't ask that question.
Correct.
Are you aware that utilities are required to file reports of unit outages as they occur if they're going to last 3 or more days?
Yes.
Did you look to see if Ameren, Missouri had filed any such reports since it made the decision to close the plant in December of 21?
No.
If indeed some reports had been made, would you anticipate that investment would have to be made to get the plant operational again?
Depending on what the outage was, yeah, I would, that could, a possibility.
Okay. Are you familiar with MISO's SSR contracts?
No.
You know Ameren, Missouri is operating Rush Island under an SSR contract, correct?
Not that I don't know.
Okay. You didn't inquire as to anything about the MISO process in your data request, correct?
I asked for the report because it wasn't attached to the testimony of Mr. Williams, as it alluded to. That's the closest to asking about the MISO process.
Thank you. No further questions.
Any commission questions? Commissioner Holzman, please go ahead.
Thank you. Morning.
Good morning.
Still morning. Yeah, we're still morning. Every once in a while, I, consider if anybody is watching these proceedings that don't have the background and the testimony and the information and are just kind of layman's following along, because oftentimes, as much as we're trying as commissioners to learn and understand and get the vocab and do the rate cases, and sometimes we also are, trying to learn as we go. So I just want to make sure I reiterate what I just heard in that testimony as if I was someone watching from home. Essentially what I heard was you came up with a $27 million difference between the company and the staff's numbers based on stopping the evaluation in 2021?
No, so I didn't include additions or retirements after 21. I still built reserves forward as they would have been accrued. And then I also did from the staff's, I think it was Cerebral True-Up EMS, and brought that forward as well. But with using the depreciation as a starting point is where the main difference comes from.
Okay. And the company asked you a series of questions about, seeking information and trying to use, past data to inform your position. And you responded by saying, no, you did not use that. Had you used that information, had you sought that data, would your numbers be different than what is shown here?
Not based on how I did it, no, because I stopped the additions. I mean, if I would have taken the additions into account and used an average and thrown them in, it could have been.
What was the reasoning or justification for stopping when you did? Like, where does that, was that a statutorial direction? Was that something that has been a precedent or tradition stopping, or were you told to stop?
No, sorry for speaking over you.
Oh,
No,
sorry.
I just, for all of those, I didn't build in additions going forward from any of the points that I started at. That includes Mr. Lansford's schedule, that includes the staff's EMS run from the last case as well. I did the same thing across all three scenarios.
So it was just a unilateral, almost personal decision to pick that time and place to stop accruing, or stop considering the the data that obviously staff and the company continue to get to the 468.9.
They took into additions after, and brought forward, yeah, it's all about the starting point and where I didn't keep additions moving forward.
Okay, so was staff wrong in continuing to make those additions in your estimation? Are you correct in stopping when you stopped, and staff is wrong in continuing?
Staff looks at things differently than me. I mean, I don't know that there's a right answer there.
Okay. All right. Thank you very much. Thank you, Judge.
Thank you, Commissioner Holzman. Are there any other commission questions? I hear none. Mr. Robinette, I have a few questions for you. Do you have your testimony in front of you?
I do.
On page 6 of your testimony, on line 4, there is maybe it's an acronym, it's AACE. Can you define that for me? I currently, and just to read to you, I currently have discovery pending to get better understanding of the different levels of study by AACE and the accuracy and detail required by each level.
Judge, I can't right now. I can go upstairs and try to figure it out. I used that from one of the company's witnesses, and I think that's how they referred to it as well.
Judge Clark?
Yes.
I apologize for intervening, but that's in the retirement section, which is a subject that's being taken up shortly, right? That's not in this net portion of his testimony, so he probably has time to get that information for you before that actual issue is taken up.
Thank you. Now, do you have your schedule JAR-R-3?
Yes, I have it in printed form.
Now, your position that is that the net plant in service balance of Rush Island, if required on September 1st, 2024, is $447,398,779. Where does that amount appear in your schedule JAR-R-3?
It would be on page 2, because that would be the second tab that started with the from the depreciation study.
And what line am I looking at?
It would be way towards the bottom, Judge. Underneath, there should be like a gray line delineates where I was using Ameren's transfers from Mr. Lansford's schedule.
Would you take a second and locate that for me, please? Or did you say you don't have it in front of you, or you do?
I have it in paper format in front of me.
Does that change the line numbers at all?
I don't have line numbers on mine. It should be way towards the bottom.
Okay, bear with me just a second.
If I may, Judge, could the number, that was Travis Pringle from staff, the 779 number is what you're looking for, correct? The N779?
That is correct.
I'm finding that number at line 96.
Thank you so much. I appreciate that. Same schedule, is the October 15th, I'll just ask, is the October 15th, 2024 net plant in service amount of $442,820,805, is that also in that schedule?
It is. It's 870 though. $870,000.
Okay. I'll make that change, but that's, okay, then that may be with the confusion. Thank you very much for clarifying that for me. Those are all the questions I have. Is there any recross based upon commission questions or bench questions from MECG? The commission staff.
Yes, Judge. Good morning, Mr. Robinette.
Good morning.
And do you recall your conversation with Commissioner Holzman regarding differences between staff and OPC's approach in this issue? Is it a fair summation to say that the difference between OPC and staff is that OPC included no additional plant between 2021 and the retirement date?
For the position statement, yeah, I mean, I had multiple different starting points, so I mean, it depends on which one the commission wants to use. I put it out there for information. I think Mr. Majors also had an adjustment from what the company had.
But would it be fair to say the biggest difference is just between 2021 and whichever retirement date is ultimately picked?
Right.
Thank you, sir. No further questions.
Any recross examination from Ameren, Missouri?
None, thank you.
Any redirect from public counsel?
Yes, please. Mr. Robinette, you recall when Ms. Tatro asked you a number of questions about what inquiry you made of Ameren, Missouri regarding additions that Ameren, Missouri made post the decision to retire Rush Island in, I believe, December of 2021?
Yes.
When did you put your testimony out? Well, let me put it this way. In these cases, we have direct testimony, rebuttal testimony, and rebuttal testimony, and that's the time sequence in which those are presented, pre-filed, correct?
Yes.
Where did you put into, among those three types of testimony, what testimony is your pre-file testimony where you set out your calculation for what to use for a net plant balance?
In rebuttal.
Did Ameren, Missouri have any witness who responded in rebuttal and explained any of the capital additions post-December of 2021?
Mr. Lansford discussed the difference, the 27 million, but
when you say he discussed it, what do you mean he discussed it?
he basically took my schedules and then my understanding is he put the additions in that occurred to basically say that gets to his schedule.
Did he identify any of what those additions were? We're talking about dollars, right?
Dollars, yes.
Did he identify any of the capital investment that goes along with those dollars, what the projects were, or what the capital investment was for physically?
I don't recall.
No further questions.
Thank you, Mr. Robinette. You may step down. And that brings us to our next issue, which is issue 7, and that concerns base mat coal inventory and what was the value of the base mat coal inventory at Rush Island, and sub A to that, should the value of base mat coal inventory be included in the amounts authorized for financing using securitized utility tariff bonds. And the first witness is Ameren, Missouri's witness.
Judge, if it pleases the commission, I'd like to make a very brief opening statement just to set the context for this issue and then call my witness.
Of course, please go ahead.
Thank you. As I think the commission knows, there's always unusable coal under the usable coal pile at any coal-fired power plant. That's what we mean by base mat coal. When plants retired, you have typically, before there was a securitization statute, included the base mat coal in base rates and allowed recovery of it at its inventory value on the books at that time. The base mat coal qualifies as energy transition costs under the securitization statute, and both the staff and the company recommend including it in energy transition cost at the value reflected on Ameren Missouri's books, $1.9 million. In other words, it should be included, according to staff and the company, in the principal amount of the bonds. OPC witness Riley either opposes recovery by any means at all, including via the bonds issued in this case, or proposes an alternative value of $532,000, about a fourth of its value on the books, claiming really a theory that the base mat consists of coal first put down at the site in 1977, and since the initial cost for the coal was less than the cost of coal today, that lower figure should be used. The evidence in this case will show that A, the company has never recovered the cost of the base mat coal, and B, that the coal primarily consists of ultra-low sulfur coal that the company did not even start to burn until 2011 or 2012, and that valuing the base mat at a cost based on 1977 coal costs would greatly understate the value of the base mat coal inventory. Company witness Lansford will testify on this issue, and with that, I'll call him to the witness stand now.
Judge, if I might,
Yes.
from OPC's perspective.
Okay, so you're wanting to do a mini opening as well?
Sure.
Okay, go right ahead.
I'm sorry.
No, that's okay. I was trying to understand whether you were commenting to the court or whether you were giving an opening.
I apologize. My intent's to give a brief opening. From our perspective, Mr. Lowry is correct that coal is included in inventory, the rate-based coal is included in inventory. It gets rate-based treatment, and it has gotten that treatment for years, if not decades. And of course, as a rate-based item, it is given a return on, so there's been an income stream to Ameren, Missouri, not only for the value of that inventory, the base mat coal inventory. So Mr. Riley suggested that over the years, Ameren, Missouri's been fully compensated, and what it's recovered in rate should cover that full cost. But if the commission views otherwise, base mat of coal, of course, is at the bottom of the pile. It's where where usable coal sits on top of. So if you're going to value the coal that's used for recovery in this case or in the future, it should be done at a cost closer to the time in which it was ground into the ground and not at current values. I believe Mr. Lansford, or Ameren, Missouri, used January 2023 values, and Mr. Riley has some values that go back to 1977. And I think the issue in the case is, one, whether there's any recovery now that it hasn't already been fully recovered, and if the commission decides that there hasn't been sufficient recovery already, then at what cost does the commission value that coal inventory, or base mat coal to be currently?
Thank you for that explanation. Ameren, you may call your first witness.
We call Mitch Lansford.
I believe you're only witness for this case, or for this issue. And Mr. Lansford, I'll remind you, you're still under oath. Please be seated. Go ahead, Ameren, Missouri.
Attender Mr. Lansford across.
Any cross-examination from MECG? Any cross-examination from the commission staff?
No, thank you, Judge.
Any cross-examination from the Office of the Public Counsel?
Just briefly, thank you. Mr. Lansford, for purposes of the base mat coal value, how did you arrive at the number that your roughly $2 million number that Ameren, Missouri is putting forward?
Yeah, we relied on a settlement position that's been carried forward, I think, since 2008, an agreement amongst the parties, from 2008, and has been carried forward and utilized in rate making ever since that point in time.
So the value you use for the, well, what was in that settlement that you're referring to?
I'm really not sure. Like the number, I'm sorry, Mr. Williams, the number or what was the basis?
Well, you said you based it on a settlement. What was in the settlement? Was there a per ton amount? Was there a total number of tons of coal? Was combination of the two something else?
The amounts that we've carried forward since that 2008 case included a quantification of tons and price and an extended price to the $1.9 million that I put forth in this case.
And that was a 2008 per ton price, or did you use a current price whenever you came up with the nearly 2 million?
I did not change the price from that, from that historical point in time, originating back approximately 2008.
What was that price, or what is that price?
I'm not sure if I have that in front of me.
Would it be a confidential number, given it's a 2008 coal price?
I don't know the answer to that either.
I don't think it would be.
I can't imagine why it would be. Do you have your work papers?
I do not.
May I approach?
Yes.
May I approach?
Yes.
Mr. Lansford, I'm handing you some documents that I believe are your direct testimony work papers. From your direct testimony work papers, would you take a look at the first page at least? And if you prefer, go ahead and look through the entirety of it.
It's all the same page.
I'm sorry, I didn't realize that.
I do have my computer right back there that has those work papers on there. If,
I think this page will be sufficient, but that is a page from your work papers, is it not?
it appears so.
Well, do you need to do something more to confirm it?
I could confirm it by looking at my computer.
I'm okay with that.
It's up to you whether you need to do that or not.
Let's see. Maybe we can see where the questions go.
Okay. On that work paper, there's a line towards the bottom above total coal that says Rush Island. Do you see that on the left side?
I do.
And then if you go across, there's a column that says unusable base in tons. And there's a figure there. I don't think there's anything confidential about that figure, is there?
I don't think so.
And that figure is
Which figure there?
under the column unusual base, and I believe it's in tons for Rush Island. If you go through the intersection of that row in that column, the figure there.
53,000 tons.
And then if you go further to the right, there's a unit price on that same line, the Rush Island line, in the unit price column.
I see that.
And is that the number we've been talking about from 2008?
I'm not sure that it is. I don't think it is.
Is that the number you use for coming up with your nearly $2 million adjustment?
can check real quick. Doesn't appear so.
Okay.
The multiplication of 53,000 tons times the unit price in that column does not equal the amount we're talking about.
Well, let's go the other direction. Well, did you use the 53,000 tons?
I did.
So let's go the other direction then. Let's take your nearly 2 million and divide it by the 53,000 and tell me what that number is.
$36.29 per ton.
So was that that value's from the 2008 stipulation according to you?
Correct. And maybe I'll clarify, I mean, that value has been carried forward and relied on by staff and all the other parties in rate cases since 2008. But I'm not aware that there is a exact stipulation. Use the term stipulation.
So you're saying it's been an undisputed number, but not a settlement number?
I don't know whether it is or is not a settlement number. I don't have any knowledge of the history dating back to 2008, but other than the fact that it has been carried forward since then.
Do you know if the commission ever reviewed it as a contested matter since in 2008 or since?
I do not know.
May I approach again?
Yes.
I have no further questions of this witness at this time. Thank you.
Are there any commission questions? Go ahead, Commissioner Holzman.
Thank you. Thank you. This base mat coal, is it used and useful?
Used and useful is a concept, typically, thought of from a plant investment standpoint, but it is, so that's an accounting term that I'm more familiar with. Is it used and useful in any other context? I mean, it's required to be the foundation of the coal pile. We need that base mat coal such that we can pile the other coal on top of it and then deliver that coal from the pile to our energy center. So from that perspective, I would say it is used and useful.
Help me understand from a logistical standpoint why you need coal instead of why not another platform? Why not like steel or gravel or some why does it have to be a fuel that is the foundation for the coal pile?
That's beyond sort of my understanding or knowledge as a finance and accounting expert here, but I know that it's common throughout the industry to have base mat coal at the bottom of each of these piles.
What will happen? What is this base mat coal good for now? Like, what will be done with it? Will it be just broken up and destroyed? Can it be burned?
It can't be burned. When the plant retires, it's unusable. It has no other purpose. I think environmental regulations require it to be removed from the site. And as we think about valuing the base mat coal, is something related to your question. We have an amount on our books for that inventory today, all of our coal pile, whether it's base mat or usable. And we're going to endeavor to use all of the usable coal that we can. And whatever can't be used at the end of the day, whatever that amount is, whatever that value is, will be the write-off and will be the final amount of base mat coal. And so valuing it here, is important because you have to put a number on it, but the final actual determined amount will be determined in the future and will be reconciled to whatever estimate we come up with in this case. And
So OPC suggested that this base mat coal has already had a return during previous rate cases. Is that an accurate assessment?
I heard that.
Do you agree with that?
I don't agree with that. I think OPC's, opening statement there was premised on the fact that a return on would somehow compensate the company for a recovery of their initial cash outlay, and I don't agree with that
Okay.
at all.
I didn't quite fully get this resolution between you and OPC that this 1.9 million reflected 2008 value of coal. What was the end result there? You know, I know you didn't have your laptop, but based on that exchange, was this 1.9 million factored in based on the value of coal in 2008?
Because it originated from that time period, I believe it did reflect the pricing at the time, but I don't have direct knowledge of what occurred.
Do we know what the delta has been between 2008 and 2024 to 2023?
The schedule that Mr. Williams from my work papers put forward to me reflected a current coal price as of our last rate case, I believe it was, of that $38 per ton, which is not too different from the $36 per ton that we backed into, or we calculated based on my numbers.
Is it possible that you used 2023 value of coal for this to arrive at this number?
I don't think it's possible. I mean, no, I don't think so. The $38 per ton is the amount that existed as of that prior rate case that was in 2022.
Okay.
It would only be by coincidence if it was the same or similar number.
Okay. So your testimony is, and I'm happy to let you go get your laptop if that insight would clarify this question. If we can put to rest whether you did or did not use 2028 value for certain, I'm happy to take a small recess and let you go get your laptop to decide that.
Commissioner, why don't, Mr. Lansford, why don't you go get your computer? Is it in here in the room?
Yeah, that'd be great.
That would be, thank you, Mr. Lowry. And that's because I'm going to be asking you some questions regarding your work papers as well.
Oh, that was just yeah. Yeah, if I said 2028, I meant 2023 or 2008. Yeah. Yeah, 2008. I meant to say 2008. Yeah. And I guess my question is, I'm just seeking confirmation that you did indeed use the value of 2008 settlement as the basis to come up with the 1.9 million.
Apologies, there's a lot of work papers here. Okay.
It's okay, take your time.
Yeah, I confirm that. I did use the amount from that prior settlement. No portion of my calculation relied on the $38 and $38 and almost 13 cents unit price that existed and that we utilized as of 12/31 of 22 in our last rate case.
Okay, so
I can if that's helpful, I can kind of demonstrate that in the spreadsheet to the judge. Maybe if we get to that point.
okay, I just wanted to make sure that we were correct on that. So then my next question is, you've had a return, a rate of return, but you said you haven't gotten recovery. The base mat coal doesn't have any useful value today. Do you believe that the ratepayers should pay interest on, if the commission grants recovery of the 1.9 million, do you believe that the ratepayers should pay interest on that recovery?
I do, and I go back to, and maybe, take exception to your statement in there that there's no used and useful aspect of this base mat coal. The base mat coal has been an inclusion rate base. All parties have agreed with that in each of our prior cases that I've been involved with. It has a necessary and useful function in terms of propping up the usable coal as part of the coal pile. So with that background, I would say it's completely appropriate for customers to pay interest via a securitization transaction like we're contemplating here in order to avoid the rate base return that would otherwise exist in traditional rate making.
Okay, and you may not be able to answer this question. This is my last question. Was the base mat coal usable fuel before it was, hardened over time into the foundation? Like, was it when it was purchased, if it hadn't been used for the purpose of creating a foundation for the usable coal, was that fuel usable at the time it was bought?
Yeah, so we did respond to a data request that kind of gets to your question, or partially to your question here. As I understand it, the coal pile is sort of evolving over time, and it's not appropriate to think of base mat coal as something that you just slap on the ground back in 1977 and exists, in that format forever. There's some sort of churn. We've done some studies, and we responded to a data request in this case that said, as we drill down and bore into the pile, primarily what exists, at the bottom of that pile and where base mat would be is ultra low sulfur coal. We didn't start burning ultra low sulfur coal until 2011 or 2012 at some point in time around then, and certainly we were burning Illinois Basin coal back in 1977 when the plant was first commissioned. And I think that demonstrates the sort of churn of the pile. What's usable, at what point in time versus base mat at what point in time is pretty speculative.
So I guess from my own understanding, in what year was it laid down?
I think the plant was commissioned in 1976 or 77.
Okay, so 1976, it's a good year, by the way. It's not like you purchased a particular type of coal that was going to be base mat for the purpose of base mat. You bought coal and just only took from the pile until the foundation was left, and that eventually became unusable over time because of environmental factors.
Yeah, we dumped coal on the ground, made a pile of coal and continue to, add to that pile and subtract.
Just over time, some of it became unusable.
That's exactly right. It mixes into the ground, over time and to provide that foundation.
Okay. All right. Thank you very much. Thank you, Judge.
Thank you. Are there any other commission questions? I have just a few. Is coal inventory depreciated, or does it have any sort of depreciation expense associated with it?
It does not. It's accounted for as inventory, which means that it's going to be expensed off our balance sheet over time as we burn the coal at the facility.
Thank you. What work schedules do you have, or what work papers do you have that are associated with this issue?
Just one.
Can you give me that schedule number?
Yes. Well, schedule. I have no schedule, just
Okay,
a work paper.
Okay, it's just a work paper. Well, let me ask this. This would be helpful to me. Are there any objections from any of the parties if I were to ask to make Lansford's work paper regarding this a commission exhibit?
No objection from us. Isn't it already part of your testimony? Is it already in EFIS or is it not?
We did file all of my work papers, based on an order from you, Your Honor.
Okay.
But that's different. I guess I'm making
this is
an exhibit.
attached. There was a number of those were the work papers, because I believe I had asked for 3 schedules from you. But that's included in there?
The work paper supporting those three schedules is what I believe you asked us to file, and it is included in that submission, yes.
Do you know which schedule it's associated with? I've got MJLD1, D2, and D3.
We also provided as updates, you may recall, the same schedules from Surrebuttal. So I can work off the direct schedules or Surrebuttal for this particular issue. There was no change between the amounts. So it would, but you have my direct work papers in front of you. Is that correct? It starts,
I don't have them open now, no. I have my order telling you to file stuff in front of me open, but I haven't got your work papers open. I wasn't following along line by line.
If you open, please, the Lansford schedules MJL S5-S8 work papers, I think that is the best and easiest.
Say that again.
It's an Excel file, and when we filed it, it was titled Lansford Schedules MJL S5 to S8 work papers.
And it's in there?
Yes, it is a tab in that workbook.
Okay, I'm going to call the base mat work paper. I'm going to call that Commission Exhibit 606. Are there any objections to admitting Commission Exhibit 606, Lansford's base mat work papers, onto the hearing record? I hear and see none.
Judge,
I'm sorry, actually, yes, go ahead.
I request some clarification on that. Are you talking about the work papers to the schedule that Mr. Lansford just testified to, all of them, or are you talking about a tab in there?
When I'm talking about right now, I'm talking about the singular, he said it was a singular page. And so I'm talking about the singular page that covers the value or the calculations and valuation of the base mat coal.
Maybe Mr. Lansford did this, but that tab, that singular page the judge referred to, that tab has a name, is that right?
Yeah, the name of that tab is MAT, M-A-T, ampersand, SUP2.
Say the last part again, please.
M-A-T,
ampersand.
SUP2. Materials and supplies, I think is what it's trying to.
Thank you, that's helpful. I'll say it, and I had the number, I wanted to assign it wrong anyway. The base mat coal work papers of Lunsford, tab MAT ampersand SUP2. I would like to call that Commission Exhibit 605. Are there any objections to admitting Exhibit 605 onto the hearing record? Okay, Exhibit 605 is admitted onto the hearing record. Thank you, Mr. Lansford. I have no further questions for you. Is there any redirect based on commission or bench questions from MECG? MECG is no longer here. From the commission staff?
No questions, Judge. Thank you.
From public counsel?
I do have a little bit of cross.
Cross or recross based on commission questions?
Recross based on commission questions.
Thank you. Go ahead.
In response to Commissioner Holzman, you talked about the 2008 settlement. I'd like to return to that for just a bit. Was there an explicit amount of coal price and base mat quantity set out in that settlement agreement?
I don't know.
If there was, it would be set out in that settlement agreement in that case?
I don't know.
And physically, whenever coal's removed from the coal pile to be burned, from which part of the pile is it removed?
I don't know the answer to that either.
So you don't know if it's taken off the top of the pile, the bottom of the pile, the side of the pile?
No, I see the big dozers, you know. I mean, the pile is, I see the big dozers out there. I don't know what part of the pile.
And at Rush Island, is there one coal pile or are there multiple coal piles?
I believe there's only one.
No further questions.
Any redirect?
Yes, Your Honor, thank you. You were asked some questions just now on, and I think in the initial cross-examination too, about this figure that came out of the 2008 rate case, right?
Correct.
And Mr. Williams just asked you, do you know whether those figures were set out explicitly in a settlement? And you said you didn't know, right?
Correct.
Do you know whether the company in its case filing provided tons and price in evidence for base met coal in that case?
I think we would have to.
Do you know whether there was actually any contrary evidence provided by anybody to dispute those tons or that price?
I don't know, going back all the way through 2008. I mean, I know that we've been presenting the tons and the price, you know, from that point forward all the way through our 2022 case, and there's been no concern, dispute, or challenge to those figures.
By OPC or anyone else?
OPC or anyone else.
I don't think you know this, but I'm going to ask you to try to help answer Commissioner Holzman's question a little bit more. Do you know if there's a reason not to use concrete or steel or some other substance to form the foundation as opposed to using coal?
I do not.
Okay. Do you know anybody who's testifying in this hearing that might know that?
We do have a witness, Jim Williams, that I'm certain can answer that question.
Okay. I think this might have been clear, but I just want to make sure it is. The securitization statute, as you understand it, requires a reconciliation process in future rate cases, right?
That's right.
So the way it would work is if, when we're done and we figure out exactly how much unusable coal, base mat coal is there, if we determine that the quantity's off and we come up with, I'll just make this up, 1.5 million or 2.5 million, either way, the amount that's ultimately going to be reflected in customer rates is going to be what the actual amount is, regardless of the amount we put in the bonds, right?
That's right. All we can do is estimate base mat coal at this point in time. That's what we're trying to do here. And at some point in time, like I was explaining to Commissioner Holzman, the actual amount will be known. We'll use everything that we can use, and we'll have to write off the remainder. That represents base mat coal. And any difference between our estimate here and the actuals later is reconciled as part of a future rate review.
Okay, thank you, Mr. Lansford. Those are all the questions I have, Judge.
I believe there is another commission question.
Thank you, Judge. As I was sitting here listening, it makes me wonder, again, from the perspective of the ratepayer. You bought this coal in 1976, and I understand that you're probably correct that there's probably some churn, and maybe that original batch of coal you bought in 76 may or may not be what makes up that base mat 48 years later. It may or may not be. But what is the reasoning, if let's say you bought this in 1976 and you didn't use that base mat because it was required to be there? So you brought it in at this price. Why are the ratepayers appreciating that value? OPC suggests that that you should recover the cost of the coal when you brought it in because you didn't use it, you didn't burn it, and the purpose of it being used is still intact for what you bought it for. If I bought lumber for a house in 1976 and I built the house and the house is still standing, that lumber, the value of that, now the home will have appreciated just like your plant will have appreciated, but the 2x4 in there, if I was to, take that 2x4 out of that house and go to resell that 2x4, it's 48 years old, just like your coal at the bottom of that pile is 48 years old. So why are you all of a sudden, even at a 2008 settlement, which we agreed that's where you set the price at, why does the ratepayer have to pick up an appreciation cost for coal they bought in 1976 that hasn't been used and is still functionally doing the same job it was at the time you bought it? What is the reasoning for why the appreciation in value?
Well, I'll kind of take a step back here and just to, just from a foundation standpoint, in our accounting books and records, there's no way to delineate between base mat coal or usable coal. It's all coal inventory. So it's just one balance, one amount. It can't be separated out like, maybe you're suggesting this 2x4 from the past. The entire coal inventory that we have in our books is supporting the operations of the plant and benefiting customers through that means. And we're producing a weighted average cost of that coal pile, the entire coal pile, and as we burn coal at the plant, we're taking from or subtracting from the pile at that weighted average cost. It is one pile at one weighted average cost, and I think that would also be an appropriate way to look at it.
So if it's one pile at one weighted average cost, why are we delineating it out and assigning a $1.9 million value under the determination of base mat coal? Why is there delineation of base mat coal and a value associated with it if we're going to take it as the entire pile? Like, what's the purpose of doing that?
In my mind, the only purpose of doing that is trying to understand or quantify or determine what that quantity might be in the future that represents base mat coal. And what price will what price and quantity will ultimately be attributed to base mat coal? We'll know that when we use all the usable coal. The remainder will be the base mat.
You'll be able to determine that. Not that we need to get this granular, but is there any way to carbon date what is left over in terms of what was actually purchased in 1976? I just fundamentally as putting myself in the shoes of a ratepayer, thinking that this coal served its purpose. It was bought at this time, and now you're giving it a value that's been inflated just through normal inflation over the last 30. Well, what's 2008 minus 1976? So 32 years or whatever that is. I'm trying, and then you want to earn interest on top of it. It's not just a recovery. It's not just that you're getting the money back for the money you spent on it. Even if we were to say, all right, well, the recovery makes sense at the value of 2008. At this point, I'm thinking arbitrarily, but for whatever reason, you arrived at 2008 was the year that settlement was going to be the authority, and we're going to say 1.9 million. Like, to earn then an additional interest on the recovery of that after you had a return on that over the last year since it was placed. I just want to understand why the company is in this position.
I hear your concern, and getting it right for customers is ultimately our goal, and I think the goal of the statute. As you think about and just refer back to the reconciliation provisions that I understand from the statute, whatever that final amount is what we're going to have to compare to this estimate, and we will either refund or collect the difference between that estimate versus actual. And that's how I feel like customers are really being treated appropriately and fairly as part of this
From an
process.
accounting perspective, have you seen any securitization that would book interest for a future return in a rate case? I know securitization is brand new as a concept and an applicable process, but you know, from an accounting perspective, we will know if the value of 1.9 million goes into those bonds, we're going to know what the amount of interest off that 1.9 million is going to generate, and you'll get it up front. Like, is it possible from an accounting perspective to book that interest to be considered in a future rate case?
I don't think so. You know, just by nature of the securitization transaction, once we commit to the bonds, we have to commit to recovery. I think we could potentially fail debt service if we decided to then carve out some amount for consideration or
Rebate of a certain
disallowance.
portion of the interest back
Right.
in the next rate case. Okay.
I'm not an expert, in terms of an underwriter or something like that, but I think anything that we did to call into question whether or not those amounts would be recovered would be a
Does the
big
interest
concern.
ultimately flow back to the shareholders?
No, the interest flows to the bondholders, the people who are investing in the
Okay.
in the bonds.
Okay. All right. Thank you. Thank you, Judge.
Thank you, Commissioner. Any recross based upon commission well, let me ask first, are there any other commission questions? Any recross based upon commission questions from the commission staff?
No, Judge, thank you.
From the Office of the Public Counsel?
Yes, please. During your questioning by Commissioner Holzman, there was a reference again to the 2008 rate case. I probably should have done this earlier, but do you know the case number for that case?
ER 2008-0318 is the reference that I have on my schedule, or on my work paper.
So if the commission were to take notice of the settlement agreements that were in that case, it should be able to determine from those whether or not there's anything explicit regarding coal pricing.
Yes, I believe so. If there's something in there, they should be able to see whatever's in there.
But if I understand what you've said to this point, there's been a course of conduct by using a certain value for coal pricing and inventory and base mat since that case that has not been disputed. Is that correct?
That's correct.
No further questions.
You had posed, this is just a question for the attorney, you posed the idea of the commission taking notice of the stipulation and agreement in that case. Do we know, a lot of times these things are sort of black box settlements. Do we know that that's actually explicitly in there, such that the commission would understand it? Or is it a term that's kind of agreed on that the parties all understand?
Frankly, I don't know what's in there. I know I just looked, there are a series of stipulations and agreements or settlement agreements in that case that the commission, I believe, ultimately approved. And I'd ask the commission to just take notice of them and it can look for itself to see whether or not there's anything that explicitly addresses the price of coal and base mat quantity.
Give me that case number again, please, Mr. Lansford.
The reference I have here is ER 2008-0318.
I'm not going to take official notice of it at this time, but I will take a look at it, and the commission will determine later whether to take official notice, and if it does, it will query the parties for objections.
And to be clear, I'm just referring to the settlement agreements and the orders related to those, not the entirety of the documents in that file.
And Judge, to that point, and I appreciate that you'll give us a chance to object. I don't know that I would have an objection, but to that point, there might be some other things in that file that official notice ought to be taken of as well if you were going to that bears on this issue, and it's going to require us to take a look at it. So if you do inquire about an objection, it may not be an objection unless you also don't take notice of these things. So I'll look at it in the interim and try to be prepared to address that if you decide to go down that road.
Thank you. And this, I'll just put settlement agreement as to coal pricing.
And Judge, since Mr. Lowry has raised it, I don't see that public counsel would be opposed if Ameren, Missouri views that more than just the agreements and the commission orders would be required for purposes of the coal value, per ton coal values and the quantity of base mat coal.
Okay. Thank you. Like I said, I'm not going to take official notice of it this time. I'd like to look at it first. Anything further from public counsel?
Thank you, no.
Any redirect?
Just, I think, a very little bit. Mr. Lansford, from a financial standpoint, is the company financing all the coal, the usable coal and the unusable coal, as it sits there on the ground at all the coal plants?
Yeah, absolutely. At its weighted average cost of capital included in rate base, in rate cases, every rate case that I've been involved in, yes.
If financing costs were not provided through the revenue requirement and rates, would the company fully recover its actual revenue requirement, what it costs to provide service to customers?
Absolutely not. It'd be, it would miss out, fail to recover those financing costs, those real and existing financing costs.
And I think Commissioner Holzman actually cleared this up himself at the very end, but I just want to be crystal clear about this. When a securitization happens, the company gets cash equal to essentially the unrecovered amount, when we're talking about rate-based items, the unrecovered amount. So the company gets cash equal to that investment in the plant, coal inventory, things like that, right?
Correct.
And then, as proposed in this case, the company's proposed a deferral mechanism to make sure it doesn't double dip and doesn't continue to keep a dollar of rate revenue associated with that, because you already got the money, and you can give back the amount that's in current rates in a future rate case to make sure customers are made whole, right?
That's exactly right.
But the way the securitization bonds work, I think, is a special purpose entity is created, the bonds are sold, and the principal and interest is paid on those bonds through that dedicated charge to the special purpose entity, right?
That's right. The securitized utility tariff charge is, it's my understanding that is the property that the special purpose entity receives.
It's not even utility's property anymore, right?
That's right.
Utility's not receiving the principal or the interest, right?
That's correct. The special purpose entity is.
Okay, thank you.
Mr. Lansford, you may step down.
Thank you.
I did not expect this issue to take as long as it is taking. However, I would like to finish it out before we take a break for lunch. So with that, I believe the next witness is Witness Majors for staff. So go ahead and call your witness.
Thank you, Judge. Staff calls Keith Majors to the stand.
And Mr. Majors, I'll remind you, you're still under oath. Go ahead, staff.
Thank you, Judge. At this time, staff tenders Mr. Majors for cross-examination.
Any cross-examination from public counsel?
No, thank you.
Any cross-examination from Ameren, Missouri?
Yes, Judge, thank you. Good morning, Mr. Majors, or I guess it's afternoon now.
Good afternoon.
The staff did not take issue with the company's base mat coal valuation for inclusion in energy transition costs, correct?
That's correct, and that like amount, the 1.9 million is currently included in the schedules for the securitized cost.
Now, in your surrebuttal testimony, you didn't change your position on base mat coal, and you're still including the 1.9 million in your recommendation, correct?
Yes, that's correct.
But I think you said something like that the $532,000 alternative might also be appropriate, or something like that, right?
Yeah, I mean, I'll give OPC and specifically Mr. Riley credit for finding that 50-year-old figure, I would assume, down in the microfiche on the first floor. I gotta say, I'm impressed by him finding that.
It's your understanding that that $532,000 figure is based on the cost of the coal when it was, of the first coal delivered to the plant back in the mid-'70s, right?
Right, just as a technical point, I think it's 562, 436. I think you said 532.
Maybe I'm off by 30,000, I apologize.
$500,000 is a good approximate number.
And the point that's being made with pointing to that figure is that the coal, that base mat coal, that original coal delivered to the plant, the theory is from Mr. Riley, is that that coal is still there, so that's what the base mat is worth. That's your understanding of the point, right?
Right, I don't necessarily disagree with that theory.
Well, you don't know in fact whether or not the base mat that's at the plant today actually consists of the coal that was dumped on the ground nearly 50 years ago, do you?
No, I think I'll call it maybe a phenomenon, but the base mat does churn as you're constantly loading, well, not constantly, but on whatever schedule, you're constantly dumping coal onto the pile, and then you're constantly taking it out and putting it in the coal hoppers, so that the coal itself is fungible, so, whatever coal was there, some of the old coal gets taken out, some of the new coal goes in, but, the base mat is really the 18 inches, the bottom 18 inches of the coal pile, generally speaking, is what's considered base mat. So to answer your question, no, I don't know if the physical coal in its entirety is the same coal that was delivered in 1975 or 1977.
Do you know when Ameren, Missouri started burning ultra-low sulfur coal?
I think it's been mentioned it's sometime in the late 90s, so I'm not going to dispute that.
Well, didn't you hear Mr. Lansford say it was actually in 2011 or 2012 when the company started burning ultra-low sulfur coal? I want you to assume that's the case. That's what the record reflects from Mr. Lansford's testimony. Did you think I was talking about low sulfur coal, Wyoming coal generally?
Right. I mean, there's three types. The plant was originally built for eastern Illinois coal, is my understanding, and then I think there is some differences based on what mine you get in Wyoming on whether it's the ultra or the low sulfur or the ultra low sulfur coal. So I'm going to assume that's correct. I mean, yeah, I'll take it on good faith.
Certainly the coal that was delivered in 1977 wasn't Wyoming coal wasn't low sulfur at all, right?
No,
You
it was
agree with
not.
that? Judge, may I approach? Need to get an exhibit
Yes, you may.
marked. Judge, I believe our next exhibit number is 25. Is that right?
Correct.
Thank you.
Mr. Majors, if Ameren, Missouri, well, let me back up. Have you seen this data request response before?
I mean, not before today, but it's an OPC data request. I'll take that I'll take it on good faith that it's the correct data request response.
I mean, what it is, it's a response to OPC data request 8,506 in this docket that was answered by the company in December of last year, right?
Right.
And what it indicates is that the base mat coal at the Rush Island Energy Center is primarily composed of ultra low sulfur coal, right?
That's what the data request says.
Now, if Ameren, Missouri didn't start burning ultra low sulfur coal until 2011 or 2012, and if the base mat primarily consists of ultra low sulfur coal, what was paid for coal back in 1977 isn't representative of the coal that's on the ground now, is it?
Assuming that that the testing method is correct, I mean, I think that would be a safe, that would be correct.
And the company obviously couldn't have made these statements in the data request response unless it's done some kind of sampling or boring into the base mat to figure out what's down there, could it?
I would agree with that. I don't know specifically that any core samples have been taken, but yeah, I'm going to agree that they would have had to have some knowledge of what's at the bottom of the pile.
I mean, you do know, you've been at the commission a long time, the commission's data request rules require the company to, answer the question truthfully, and by answering the question, the company's representing that they're giving accurate information, right?
Yes.
Obviously, I think you said you hadn't seen this data request response before now. So when you said Mr. Riley's alternative valuation was appropriate, you didn't know about this, did you?
No.
Am I correct that when a utility receives a return of an investment, that is different than the utility receiving a return on an investment? Is that right?
That's correct.
And the return on is designed to cover the financing costs that the utility is incurring to finance that investment, right?
Yes.
Thank you, Mr. Majors. Those are all my questions. Judge, if I could, I'd like to move for the admission of Exhibit 25.
I object. There's no foundation for the admission of this exhibit. It's obviously self-serving by the company.
Well, Mr. Majors identified it as a data request response in this case. I don't think OPC is disputing its authenticity.
Why wouldn't you just bring this in through OPC's witness?
I can certainly ask Mr. Riley if this in fact is his data request response. The reason I asked Mr. Majors about it is he made a recommendation not having this
No,
information.
I understand why you asked him, and he's been able to testify on it, but I think it would probably better come in through.
I'll
witness
ask
file.
those questions.
Okay, thank you.
Very well.
And you said that ended your line of questioning?
It does, thank you.
Any redirect from staff? Oh, actually, I'm sorry, it's time for any commission questions. I apologize. Go ahead, Commissioner Holzman.
I also didn't necessarily have on my bingo card getting bogged down on this issue today, but since we're here, let's see if we can't figure this out.
Sure.
For starters, I think maybe Jim Williams was the name that the company provided that could potentially definitely answer this question. But in the time that you've seen your involvement with coal plants, why do you use usable coal to set a foundation to stack other usable coal on? Why not concrete or steel or some other, floor?
Well, I think really the reason would be it's plentiful and readily available. If you think about the coal pile, it's acres in size. So if you think typically the engineering firm, the one that comes to mind is Micon, MAKON, but there's other engineering firms that do coal pile evaluations. The coal pile, the base mat, coal pile and base mat evaluations. So the base mat is it has to be a minimum of 18 inches, and that's what's considered base mat, at least from my recollection, and it's the entire size of the pile. So it's readily available. It would be if you, let's say you did concrete, and again, I would ask Mr. Williams for more of a technical reasoning and explanation, but you have to have the concrete delivered. I mean, you're talking about acres of concrete. Those costs would add up pretty quickly. So if you think about, and I'd asked Mr.
Well, you
Williams.
can pour a lot of concrete for 1.9 million, though.
Well, that could be true, but I think size would come into account. You're talking about literally acres. I mean, 5 acres. I'd ask Mr. Williams on the actual physical size of the pile.
Okay. I'll save those questions. So based on what we're seeing here, the high sulfur Illinois basin coal would be the stuff that was bought in the 70s, right?
Right, that's correct.
And what we were presented here essentially is making the argument through the data request that it's indeterminable how much of that coal, pockets of it exist, but there are other coals mixed in, so it's proof that 70s coal is not necessarily what the base mat is made up of today.
That's a fair point. I mean, I don't know that they've done. I don't know of any utility that comes to mind that would actually take core samples to the very bottom of the coal pile to determine the type of coal. I mean, that's certainly possible, but
What do you think the reasoning is for using the 2008 settlement to set the price of what this coal is worth today?
I'm glad you asked. I want to clear part of that up first. One, I think if you go to the bottom of Mr. Lansford's work papers, the price that he lists and the prices that I used would be of January of 23. And so I'll give a little bit of background on that. Certainly in the rate cases I've been, we've priced base mat out in terms of rate, inclusion of rate base at the current delivered price per ton. Part of the reason for that is, at least with the plants, when I've been involved in fuel expense and whatnot in the rate case, there's no really easily available price from the vintage of the unit. So if I were to go back, which we certainly can, and might be a good idea in future rate cases to go back to 1980, 73, 79, to get those prices and get a delivered price per ton for rate making purposes. Of course, if they're doing coring and they say that those tons really aren't at the bottom, then that's a different proposition. But getting more to the point, we've included, at least with the rate cases I've done, at the current delivered price at whatever Micon or their external auditor finds. On the Ameren side of the state, it's my understanding, and I explained in Sir Rebuttal, that there was a agreed upon amount in tons and price going back to 2008. I've read the stipulations for my own edification and to find out what was actually agreed to. They're not in the stipulations. Now, the revenue requirement numbers that appear in the stipulations are likely predicated upon the amount of tons at the delivered price in 2008. And so the delivered price in 2008 that the agreement was predicated upon is $28.05. That amount was used for rate making in the last case, 2022-0337.
You said 28,
$28.05.
and we heard earlier that this 1.9 is derived at 36.
Well, it's a good question. It's slightly different. So I think the way that was derived is by taking the overall base mat for all plants, dividing them by usable coal for all plants, and that's approximately 5% of the overall coal. And then there was a percentage breakout, and that is from 2008. Rush Island is 35%. And so that price, that percentage was applied to the weighted average cost, all in delivered price as of January 23 to come up with the 1.9. If you were to use the actual delivered price at I'm sorry, not 1.9, 120, January 23. If you were to use the actual delivered price at Rush Island as of January 23, it would be a little over $2 million. So I know there's several points.
What would it be
there.
if you used 2008 numbers?
Approximately 1.4. I've got that number. If you'll forgive me, I've got here. $1,486,650. So that's about a $500,000 less than what's being requested right now. So I guess part of my failure is that I priced it out and agreed with the price because that's how we do it in the rate case. In Evergy cases, we price that out at the current cost. My misunderstanding of what was agreed to doesn't appear in the stipulation is both price and tons were agreed to informally in the 2008 rate case. And so that was what was used in the last Ameren case for revenue requirement purposes by staff, looking at Mr. Young's work paper.
So
on my
do you
laptop
still,
here.
do you still recommend 1.9 million?
I think, given the response to the data request that it's not 77 coal in its entirety, I think that's fair.
Well, let me ask you that question. So what would have happened to, what, does coal decay? Does it turn into soil? Did they burn some of it, by, getting low down to the base mat? Now they're taking some of that high sulfur Illinois coal, and it's actually making its way into the incinerator.
So that bottom 18 inches after time, and just for comparison purposes, the total tons at Rush Island in the on the work papers is 737,222 tons. The base mat itself is per the agreed upon amount is 53,000 tons. So all those tons will compress that bottom level of base mat to where it's pretty hard and not, if you think about the loaders, the bulldozers that crawl along the pile and moving coal around, they will scoop up that coal, load into the hoppers. But that bottom part, it has been so compacted over time. It's crushed. I think you'd ask Mr. Williams again to describe it. I've been out to the coal pile and seen it, but I'd ask him. But that also mixes with the soil and the clay, and so there's been several other rate cases where the question of whether or not base mat is burnable, those occurred back in 81, 82, 83. It's I think it's generally accepted that it's not burnable. You wouldn't want to put that through the furnaces, through the hoppers, and have it pulverize and whatnot. There's rocks, there's soil, generally contamination. Again, I'd ask Mr. Williams for a better explanation of that.
So do you still stand by your 1.9 million as a recommendation?
I think given the agreed upon, if you're going to agree upon the tons and I think you would probably use what was agreed upon in 08. So
that'd be 1.4.
That would be 1.4 at the 08 price. It's the difference between what do we do in the rate case and what do we do when we're getting rid of the coal. We're getting rid of the base mat. There's no more coal. So I think 1.4 is a fair number because it was agreed to, and that was what was in the last rate case.
Okay. Thank you, Judge.
Are there any other commission questions? I've got a couple questions for you, real quick, Mr. Majors, and I'll try and be brief. And I want to be sure I didn't mishear you. Did you say you had read the ER 2008-0318 stipulation and agreement?
There are actually three of them, in my recollection. I went through them. There's no specific that I can read listing of tons, prices, an agreed upon base mat number. So I didn't see that in there. I've read all three of them. I think one of them isn't really relevant. It's on rate design.
But did you, and this is where I may have misheard, did you say that the $28 figure that did you say that was the number you derived from that?
No, that was a figure that I found in staff's work papers, and that my colleague, Mr. Young, I'm looking at his work papers, so he confirmed that with the 2008 work papers. Certainly the tons are the same, but the price that he used was different. Now, I tried to find Ameren's work papers. I don't find, I found the tons, but I didn't necessarily find the price that they used for revenue requirement purposes in the last rate case.
Would it be fair to say that for rate making, what I'm going to call the inventory method matters more than the physical identification of the coal pile?
Sure, and we've gone back and forth in discussion with this on how should we price out base mat. I think that having a fixed price in tons is a good thing, so we don't have to dispute that rate every rate case. Long term, the coal prices, delivered price per ton, are much less variable than, say, gas prices, which you don't have an inventory for. So agreeing to that price in tons, I think, puts aside one issue. Certainly, we haven't had a disagreement on that issue in the cases I've worked, but we do price it differently. We price it at the most recent delivered cost per ton, at least for the bulk of the coal.
Thank you. Any recross based upon commission questions? Public counsel?
Yes, thank you. Mr. Majors, in response to some questions from Commissioner Holzman, you said that the coal pile covers acres.
Yes.
Why?
Because it's so massive. I mean, you're talking about 737,000 tons of coal. I was going to see if I could find what the volume of a ton of coal would be. I've picked up a piece of coal. It's probably not unlike a kind of a light porous rock. So
Why is such a large amount stored on site?
Well, you would want to, utilities will have various methods of modeling how much coal they should have on hand. It probably way back 30 years ago, it was 90 days, but those margins have shrunk because there is a cost to maintain that inventory. There's a capital cost. So there can be at various times, there can be 30 days of inventory. There can be up to more than 100 days of inventory. It just all depends on the purchasing practices and the contracting practices of the various, of the given utility. So you would have, it wouldn't be unheard of to have hundreds of thousands of tons of inventory on hand, especially when you're building those inventories up prior to the summer months. You would want to have that inventory on hand because your demand is high.
There's been a lot of discussion about base mat being dirty. How is coal dirty?
I think I'm going to interpose an objection. I don't see where the question about why do you have large inventories in this question don't really seem related to Commissioner Holzman's questions to me. Seems like reading pretty far afield.
I think Commissioner Holzman was asking about, when he was asking about the base mat, one of the things that came up was that there were questions whether or not it could be burned because of debris in it. So if he wants to ask about whether or not coal is dirty, I think that's on point.
It's exactly where I'm going.
So that objection will be overruled.
It's it could be quite dirty. I think the best example would be former colleague Mr. Featherstone went down into the coal bunkers at Montrose, and after he came out, he was covered in soot. So I would say it can be quite dirty.
Well, isn't it why Rush Island's being shut down?
I think the context of what you're asking is coal dirty physically before it gets burned in the unit? And I think that your question is more focused on the what are the emissions impacts and is it quote unquote dirty? Is that what you're asking?
That's not exactly where I intended to go, no. Go back to the 2007 and 2010 projects. Weren't those done because the coal being burned was dirty?
No, well, as compared to Illinois coal, no, it's not. It's cleaner than the Illinois high sulfur coal. I think Mr. Lowry just said not too long ago that in 2011 that the ultra low sulfur coal was starting to be burned. So comparatively speaking, that would be cleaner than your Illinois bituminous coal or much cleaner than anthracite coal.
Well, let me try it a little bit different because I'm not focusing on emissions. I'm talking about the pluggage issues. You familiar with that?
Okay, yes.
So were the pluggage issues at Rush Island caused because coal is dirty?
Judge, I'm going to interpose another objection. I understand that the commissioner asked about whether coal's dirty, but the context was, he didn't really ask that, but the context was you have coal that's usable that doesn't have debris and concrete and stuff in it that would damage the boiler, and then you have coal that's down in the ground that has those things in it. And now we're talking about pluggage of boilers, and we're talking about two totally different contexts of what dirty means, and I don't think that has anything to do.
We did. I thought we straightened that out. I'm going to allow him to pursue this, but I would like it to end soon.
I'm just about done.
I think you're trying to get to a simple answer, and it seemed like we were almost there.
I don't recall if you answered my question about the pluggage being caused because the coal's dirty.
Well, I think the pluggage, my understanding was that the availability issues at Rush Island was because of the transition from Eastern Illinois coal versus Western PRB coal. It's not necessarily that it's dirtier, but the combustion residuals that remain in the boiler were causing pluggage issues with the associated equipment that was being replaced.
So is base mat coal just coal that's so dirty it's not burnable cost effectively in a Rush Island unit, for example?
Right. I think the difficulty of, as I said before, is that when it's been compressed over the last 50 or over several years. I mean, I think the response to the data request said that it was the core samples were of various types of coal, but anytime you have that amount of coal on, all that compaction creates an amount of coal that's unburnable. That's commonly called base mat.
Is it unburnable because of the compaction, or is it unburnable because it's too dirty to cost effectively burn?
Yes. Both.
Thank you. I have no further questions at this time.
Any recross from Ameren?
I hope just one question. The reason the base mat coal is unburnable is because it's mixed with soil and rocks and other things that might damage the boiler if you were to run those things through the boiler. Isn't that right? As opposed to its sulfur content or its blackness or anything like that. Isn't that right?
Yes, that's correct.
Any redirect from staff?
Yes, Judge, hopefully brief. Mr. Majors, just to be clear before the commission, what is staff's position regarding the value of base mat coal?
Well, I think what we recommended is the 1.9 consistent with what Ameren recommended. I think if you take the price also that was agreed to in 2008 along with the tons, I think that would be perhaps a more accurate price of cost. I mean, you're never going to get a true price, a truly accurate cost of the base mat unless you analyzed acres of core samples of coal. But I think as an approximation, and certainly what we've used in in prior rate cases, the 1.4 million is an appropriate price.
Now, regarding the OPCDR that Counsel for Ameren discussed with you, currently marked Exhibit 25, did that response change your conclusion in any way?
I think it did. That's fair. If they're doing core samples, which is my understanding of what the response to the data request was, I don't know how many core samples they did. I don't know what area they did it on. If they're doing that and it's not the if it's not the coal from 77, 75, take your pick, I think it's fair to move off that position.
And then, just because I want to make sure this issue isn't forgotten during all the talks about what coal is, what is staff's position regarding including any of base mat inventory values into the financing for these securitization?
I think whatever valuation you put on the coal base mat, I think that's a securitizable cost. I mean, there's really no other way. I would ask Mr. Williams, Jim Williams, about where the ultimate destination of that base mat is going to be. Certainly, if you don't recover it now, there's no really way to recover it. If it's landfilled, if it's retired in place, it's just going to sit there. So I think it's a valid securitized amount to be securitized, and that was consistent with what the commission found in the Liberty Asbury securitization.
Thank you, Mr. Majors. No further questions, Judge.
Mr. Majors, you can step down. Give me just a moment. I would still like to stick with my contention to get through this issue before lunch. So let's go ahead. OPC, call your next witness. I believe the next witness is yours.
OPC calls John Riley.
Mr. Riley, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
So help me God.
What is your name and how do you spell it?
My name is John Riley, Riley.
How do you spell John?
John.
Mr. Riley, by whom are you employed in what capacity?
I'm employed with the Office of Public Counsel as a utility supervisor.
Did you prepare written rebuttal testimony that includes scheduled JSR-R 1 through 4 that has been pre-filed and marked as it'll be Exhibit 207 in this case?
Yes, sir.
And did you also prepare in written form rebuttal testimony that includes a corrected schedule JSR-S-1 and then also 4 other schedules JSR-S-2 through JSR-S-5, which has been marked for purposes of identification as Exhibit 208?
Yes, sir.
For those, for Exhibits 207 and 208 to be your testimony here today, would you have any changes to them?
Not to my knowledge.
Are in fact Exhibits 207 and 208 your testimony here today?
Yes, sir.
Mr. Riley has other issues too, so I'll go ahead and tender him for examination.
Any cross-examination from the commission staff?
No cross, Judge. Thank you.
Any cross-examination from Ameren, Missouri?
Maybe just one question. May I approach?
Please go ahead.
Exhibit 25 still up there, Mr. Riley?
I have.
Did OPC ask that data request?
Apparently so, yes.
With that, Your Honor, I will move for the admission of Exhibit 25.
I object to its admission. The response has not been authenticated. If he just wants to put in the question that OPC asked, I don't have a problem with that, but I certainly do with the response.
Are you contending, Mr. Riley, that this is a falsification or of the response that was actually given?
I have some questions with the response, but
Have you seen it before?
no, I haven't.
I'm sorry, say that again, please.
No, I did not. I have not.
You have not seen this data
Data
request before?
Were you aware that the question had been asked?
No.
Well, Judge, obviously, I don't have any way to go further with the issue. It was asked by Mr. Robinette, who wasn't even on this issue. I don't think any question about its authenticity has been raised.
Well, let me ask this, Mr. Williams. Because I'm not sure what you're disputing on it. Are you disputing? They've already put on a witness. Their witnesses already said how they valued the how they came to their $1.9 million valuation. So are you disputing whether there's 53,000 tons there?
No, I am not.
Are you disputing whether the value they arrived at using the current price was 1.9 million?
It's my understanding the current price was 2023 price per ton. So,
yeah.
yeah.
Are you disputing that amount as to that point in time?
At point in time, do you mean?
Where
how
they say
came
the
up
one, at the point in time they valued it at 1.93, would you dispute their valuation based upon the current price at that time?
Okay, when you say at that time, I testified
okay.
to it.
Yeah, let me ask the question this way.
Okay.
Do you know how they derived do you know at what point in time? No, I'm not going to.
Judge, can I
No.
beg your pardon? Just a sec. Well, I was going to try to save you some time.
I understand you are, but I'd like to figure out how to
Okay.
save my own time.
Okay. Well, okay.
The 1.9 million that Ameren came up with, what price is that based on?
From the Mr. Lansford's work paper, it would be a 2023 price.
Are you disputing that that was the price of coal in 2023?
No, I am not.
So you're not disputing that they arrived at that 1.9 million based upon the price they used, which is different than the price you're using, correct?
That's correct.
Are you disputing the volume of the base mat coal in tonnage?
No, I used 53,000 tons.
I'm going to go ahead and admit the exhibit over your objection.
Okay.
I have no further questions, Judge.
Go ahead, Commissioner Holzman.
This is just a simple yes or no question. Is it possible that the base mat existing today is made up of a mixture of the coal that was procured in 1976 and additional coal that's been purchased up until today?
Yes, that's possible.
Thank you. Thank you, Judge.
And I will try and be very brief. Are you familiar with the commission's, the statute, the 393-1700, the securitization statute, permits the commission to look back to its previous securitization orders and consider those. Are you familiar with what the commission did in the retirement of the Asbury case?
Yes, sir.
Do you know the point, do you know how in Asbury the valuation of the coal was derived? Was it derived from a more recent price or from the price of the base mat at the time it was put in, or something between?
I'm not sure how it was valued at that time.
Would you agree that the commission accepted the valuation of $1.9 million for the Asbury plant as the value of the base mat coal in whole? And I believe the Missouri portion of that ended up, because it isn't completely all Missouri, I believe the Missouri portion of that was 1.5 million?
I can accept that. I mean, I could look it up. I've seen it before. I don't remember the exact number, but that seems rather familiar.
I understand the fundamental idea of fairness and the logic of going down to, the oldest coal as being at the bottom of the pile, as you would kind of expect, and I understand the churning, but isn't whatever, I mean, never mind, scratch that. I'm not going to ask that question. I'm done. Are there any questions based upon commission questions from staff, or any recross based upon commission questions from the commission staff?
No, Judge, thank you.
Is there any recross based upon commission questions from Ameren?
No, thank you, Judge.
Any redirect from public counsel?
Mr. Riley did an admirable job, so no.
All right, I have no further questions. You may step down. I'm going to say it's now 1 o'clock. We're still kind of, even though it's just a few minutes shy. We're at a later stopping point than I would like, and we're still moving a little slow, so I'm going to do a 30-minute lunch break. So if everybody can be back here at 1:30.